name Hanif
Ali.
rejected the jimma on the ground that the documents produced by the petitioner for claiming his ownership does not tally with the documents with the IWT department, and accordingly the prayer for jimma was rejected. Learned counsel for the petitioner has submitted that after rejection of the said order, from where you have procured this 31?
Lordship, this is from official, Lordship. They collect. Petitioner collected.
The petitioner collected the certificate of registration of the steam/motor vessels issued by the registering authority, that is
Governor, Lordship. Governor, this is to certify that the governor of Assam.
no, who issued it? Governor has,
Lordship, and the registering authority.
who is the registering? Which department?
England water transporting department, Lordship. Inland, Lordship, and page number 32, Lordship.
Inland Water Transport, IWT.
Issued by registering authority, that is Inland Water Transport Department. Learned counsel for the petitioner has submitted that the said document of certificate of registration is in the name of the present petitioner, and therefore he prays for allowing the jimma of the seized vessel, motor vessel, on the basis of the said document. However, learned additional public prosecutor submits that the learned court of learned addition the court of learned additional chief judicial magistrate rightly rejected the prayer for jimma of the petitioner, as he failed to produce any genuine document and before the said court, and therefore there is no error in the order which has been impugned in this revision petition, and the document on which the petitioner is now relying was not produced before the learned additional chief judicial magistrate. In view of the submissions made by learned counsel for the parties, as well as in view of the facts and circumstances of this case, this court does not find any error to justify any interference in the impugned order by this court in this revision petition. However, the petitioner is given liberty to approach the learned additional chief judicial magistrate Kamrup once again
And these documents may be
and produce the document of
annexure, Lordship.
produce the certificate of registration of the steam/motor vehicle, which is annexed along with this revision petition as annexure 1, so that his prayer for jimma of the vehicle may be considered afresh by the learned court below. With above observation, this revision petition is disposed of.
Lordship, obliged.
The petitioner before Lordship, my petitioner number 1 happens to be a reporter, and who is the reporter, and one is the editor of a proceedings. A news was published, my lord, way back in 2022, my lord. That is, your lordship, news item, your lordship will find at page annexure 2, page 20, my lord. There is says, my lord, in an obscene video of a professor of Kharaputiya, Dorong has been widely circulated in social media, which there has been a chaos in this area. It has come to notice the obscene video with a professor of Kharaputiya who was retired 2 months back, having an affair with a beautiful girl, was widely circulated, and there is a lot of controversy in the district about the character of the professor. It mentioned the various incidents of women's camp while he was in college, but the incident kept secretly. Lastly, the obscene activity has put the civil society of Kharaputiya. It was mentioned a retired professor with title Sarkar involved in the minority so and so. While he was in a college, he remained absent on various ways. So this was the news item. Now, news item is based on a social media circulation. So prior to publication of news item, there is already circulated in news in the social media about the activity of this professor, that he was having an affair with a young girl of that college. Now, now on the basis of this, according to the complainant, now this news item has defamed. So he filed a complaint in before the court of SDGM and Obey. Now my first point, now he has not denied the publication. Nowhere in the complaint this complaint you also will find at page 12. Nowhere he has denied that there was because all news item is based on the social media, whatever the Facebook that it was already circulated on the basis of the circulation. So already he has been defamed prior to publication of the news item. And I will squarely cover under exception 3 for public good if something is published. It is already circulated in the social media.
Exception 3 of
That's exception 3 of the 499.
what it says.
Exception 3 says, your lordship, that conduct of a person touching any public question. He is a professor of a college. And it is not defame in good faith in opinion, whatever respecting conduct of touching a public question, respecting the character. So far, the character appears to be conduct and no further. So already it was published, it was circulated in his media, in the social media about his involvement with a girl. Some obscene photos were also published already there. So he has already been defamed. And he has not
No,
questioned.
but it is a defense which you can take in that.
I understand my defense, but the whole news item is based on social media, and the social media, and he has not challenged the social media. There was no such, your lordship mechanism. First of all, he has to make out a case that there was no circulation in the social media. Because in the complaint, there is not a single averment that there was no circulation, nothing that sort of was appeared in the social media out of false imagination or false they have filed. But they have not a single line in the complaint. They have said that there was no circulation in social media. So my humble submission, since our case is based on social media circulation, and that social media, existence of social media was never questioned in the complaint. So my humble submission, no case of defamation has been made out. Because already he has been defamed, it was already circulated. But here, in his own account, it has been published. So, prima facie, no case under section 499 has been made out. A person who has been already defamed, he cannot challenge the subsequent circulation in the appeared in newspaper. Your lordship, that is the basically our case is. A person who was already defamed by way of social media.
No,
When-
but your newspaper reaches many other new people.
Understand, but it is based on social media circulation. And
Maybe.
already it is already circulated in the Kharupatiya town. Because he has not, it was already known.
But your newspaper is circulated
I understand.
throughout Assam.
But it's based on social media.
Maybe.
Because already he has been defamed, my lord. Once he has been circulated, the person who has been defamed. So prima facie, my humble submission before your honorable court, that complainant has not, had it been a case, my lord, he would have challenged. There was in social media a false or nothing has been circulated. Nothing, not a single line he has put in the complaint. That in social, there was no circulation in social media. Your lordship may kindly see. That is the crux of the matter. If you would have denied that there was no circulation, or there was no nothing or any sort of obscene act was there. Because there was no denial on his part. Had he filed a complaint on the ground that there was no such circulation or in anything, all circulation, nothing else, man. Not a single line has been there in the complaint.
This is 482.
482, I understand, man. But defamation, your lordship, my candidate.
No, defamation is there.
Yes. Yes, grounds of crossing, whether primary facie case is made out or not.
Prima facie, it is made out.
No, provided he makes a statement that there was no such circulation. Because there in the complaint also he has stated that on the basis of this social media circulation, it was published by them. If that is the case, that your lordship will find.
Okay, we are issuing notice.
Let there be a stay, madam.
Not
Because
after hearing the,
all the personal appearance of this accused number, petition number 1 may be dispensed with, madam, till then.
no, that prayer you can make before.
That,
the-
no, your lordship may consider personal, at least petition number 2 already appeared, madam. Petition number 1 may be dispensed with, madam. Till then, madam. Then this is the returnable then. A very short point is involved, madam.
No, why petitioner, why you are making this prayer for dispensing it?
Because he has to, because since the case is pending, let
But that prayer can be,
I
that
understand
relief
that,
can
yeah.
be given by the trial court also.
trial, yeah, they can be given, madam. That is not that. Your lordship may, there, make a observation,
It may be-
madam.
Okay,
Okay, that will.
heard Mr. P. Kotoki, learned counsel for the petitioner. This application under section 482, you have made state a party?
State, actually, it is a private complaint, madam.
Okay. This application
So
under
there is not
section
necessary.
482 of the Code of Criminal Procedure, 1973 has been filed by the petitioners, namely Jayanto Borwa and Pradeep Ghosh, praying for quashing the proceeding in CR case number 135/2022 under section 500/501/502 of the Indian Penal Code, which is pending in the Court of Learned
Judicial magistrate first class now, not Salman.
Judicial Magistrate First Class, North Salmara,
Correct.
Abhayapuri. Learned counsel for the petitioner has submitted that the respondent has instituted a complaint case which has been registered as CR case number 135/2022, wherein the respondent is aggrieved by publication of a news item in the where it was published
Published on, that is on 17th of June 2022, madam.
on 17th of, in which newspaper?
Assamia Pratidin, madam.
In Assam, in newspaper Assamia Pratidin. And it is alleged that by the said publication, the publication of the said news, the respondent has been defamed. Learned counsel for the petitioner has submitted that the news item was published on the basis of a social media post which has been widely circulated before the publication of the said news item. It is therefore submitted by the learned counsel for the petitioner that had the petitioner been defamed by the said news, it was even before publication of this
Because news item.
news item, the
Complaint.
social media, the said news was circulated through social media even before the publication of the said news. Stop. Learned counsel for the petitioner has also submitted that the petitioner number 2 has already appeared before the learned trial court. However, the petitioner number 1 has No, why what is your submission?
Petition number one, once you file an application under 205, my lord, that may be considered.
Is yet to appear before learned trial court. Issue notice to the respondents. Issue notice to the respondent. The petitioners shall take steps for issuance of notice to
And
the
a scanned copy of the LCR may be called for now.
respondent by registered post with AD within 3 days from the date of this order, returnable after 3 weeks. Let the scanned copy of the CR case number 135/2022 be called for from the Court of Learned Judicial Magistrate First Class of Airport. The petitioner number 1 may approach learned trial court for dispensing with the personal appearance of the petitioner number 1. And if such a petition is filed before learned trial court, same shall be considered by the learned trial court.
And further interim order shall be considered on the returnable date.
The prayer for interim relief for stay of the proceeding shall be considered only after service of notice on respondent number, on the sole respondent.
Oh, yes.
Let this case be listed accordingly after 4 weeks.
Awesome.
This application made for the quashing on a higher money. FR it is 11% is 24 months. Technically, there is a land dispute between the parties, and both the parties are claiming that land is belongs to both parties, There is scuffle between them, somebody injured on the either side, And same plot of land, civil case is pending before the landed civil just 2, Proximity page 36 NHRF.
No, but the allegation of assault is also there
Yes, ma'am.
in the affair.
Both parties there, because each party is claiming this, the land is belong to them, That is the problem, And for that, this civil case is pending, for declaration of right title of interest in the matter. And after hearing the parties, the landlord civil just please to.
No, what is your ground for quashing?
It is civil procedure, It is
No, civil dispute may be
Yes,
there,
Yes,
but mere pendency of a civil dispute. Here the allegations of assault is there.
379 also there.
Other allegations are also there.
That is the fact, I may claim it is a false allegation, because land is belong to me, So their question of assault, another person does not arise, This is my possession, And this, the landlord, civil judge, please to stay, please do state up procedure, Status quo is maintained. Order has been passed, so status quo maintained is there,
It is pending investigation.
Investigation yet to be started, All of the accused person all in bail,
You are on bail.
Oh, yes.
Yes.
This stage, sitting.
CD would be required. Our Mr. BP Sinha, learned counsel for the petitioner. Also heard Mr. KK Parashar, learned additional public prosecutor. This application under section 482 of the Code of Criminal Procedure Common Law 73 has been filed by the petitioners, namely Dhiraj Chaudhary, number 2 Raju Ali and Mujibur Rahman, praying for quashing of the FIR filed by the respondent number 2, on the basis of which Ajara PS case number 198/2022 has been registered. Stop. Issue notice to the respondents. Since learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps for issuance of notice on respondent number 2 by registered post with AD within 3 days from the date of this order, returnable after 4 weeks. Let also the case diary of
Ajara PS case number
PS case number
198.
198/2022 be called for. Let this case be listed again after 4 weeks at a date. Date would be required.
मतलब for CD मतलब
Let it become.
29 January, 29th of January.
29 January.
May please, Honor. In this case, the informant and his mother were the owner and possessor of a plot of land and building at Kharupatia. What happened in this case, they have taken loan from Canara Bank, and when they are unable to pay the amount, bank has put the property in auction. And my employer has purchased the same on 16/8/2023 from Canara Bank, and thereafter on 19/10/2023, which is at para 6, page number 4. Para 6, page number 4. Sir. Then the Canara Bank has handed over the possession to my employer, Ramlal Durgadat Motors Private Limited. Thereafter, they are living in the property. Suddenly on 3rd of November, the informant and his mother tried to dispossess us, and then the FIR, then they filed an FIR when we registered.
Okay. What was the allegation in the affair?
In the FIR, may I read, sir?
Yes.
Respectively, beg to inform you that we have a land situated at Kismat in Khutputia. In the morning on the said land, today on 3/11/2023 of the morning, my old mother Rupa Bora came to give a lamp. At that time, on the order of the first accused, the second accused came with a group of 10 to 15 people at approximately 1 o'clock in the daytime, when my mother was sitting on the said land, kicked and pushed my mother to the ground. They also threatened to kill her. When I came to the spot, after getting information about the incident, the accused tried to beat me up and gave various types of terrible fears, threatening. This is the FIR. And I'm an employee of the auction purchaser. I'm nowhere connected in this case.
No, is there any document to show that you have purchased?
Yes, I have.
You have not annexed with this.
I have not. Because these documents are with my employer.
Since 3rd of November, मतलब, till date, मतलब, not arrested.
No, where is the apprehension? Why are you apprehending?
2 months.
I'm appealing because police are searching. Because in the same, the owner, Vishal Agrawal was on release on bail from this honorable court. And
You are not named in the affair.
they are searching me. Her mother also filed an FIR. On the second day, Rupa Bora has also filed an FIR relating to the same incident. And on that, I was also released from this honorable court.
FIR in separate case was registered
There are 2 FIR,
and 2 separate cases are registered.
2 separate cases.
Heard Mr. A. Cabra, learned counsel for the petitioner. Let him appear, Mr. Parashar. Also, Mr. K.K. Parashar, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure from 1973 has been filed by the petitioner Dibbojyoti Soikia, who is apprehending his arrest in connection with Nagaon Sadar PS case number 1043/2023. the gist of accusation in this case is that on 3/11/2023, one Shri Hriday Bora had lodged an FIR before the officer in charge of Hoiborgaon Police Station, inter alia, alleging that the accused persons named in the FIR, namely Vishal Agarwal and the manager of RD Motors, within bracket, the present petitioner, had on 3rd November 2023 in the morning came to the land belonging to the first informant and assaulted the mother of the first informant, and also tried to beat up the first informant and retain the first informant. Stop. Learned counsel for the petitioner has submitted that the land of the first informant was auctioned by which bank? By
Canara Bank.
Canara Bank,
Nogam branch.
Nagaon branch on 16/8/2023. And the employer of the present petitioner, namely RD Motors. Who is your employer?
Ramlal Durgadat Motors Private Limited.
Ramlal Durgadat Motors
Private Limited, Nogam.
Nagaon had purchased the said land in that auction and took possession of the said land. However, on the date alleged in the, on which date?
19/10/2023.
However,
Possession was handed over.
and on 19/10/2023, the possession of the said land was handed over to the employer of the present petitioner. It is also submitted that when she came to dispossess you,
See on 3rd of November.
that on the date mentioned in the FIR, that is on 3rd of November 2023, the informant and her mother came to dispossess the petitioner and the employees of the petitioner's other employees of the petitioner's employer from the said land. And when they resisted, a false FIR has been lodged against the present petitioner. It is also submitted by learned counsel for the petitioner that the police is now searching for the present petitioner, which has caused apprehension of getting arrested in the case pending against the present petitioner. It is also submitted by learned counsel for the petitioner that the accused number 1, namely Vishal Agarwal, has already been allowed to go on bail, by which?
In AB case number 4348.
By the High Court.
By this.
By High Court, by this court in AB case number
4348.
4348
2023.
/2023. Stop. Whether Mr. Parasha, CD would be required and we can dispose it off.
No, my lord, this is giving the interim, my lord,
I am
Learned-
no way connected.
Okay, learned counsel for the petitioner, learned additional public prosecutor, on the other hand, submits that the result of the case diary would be necessary. Hence, call for the case diary fixing
2nd of February, my lord.
2nd February for case diary. However, in the meanwhile, considering the facts that the co-accused has already been granted bail by this court, the petitioner, namely Dibbajyoti Sakya is also directed to appear before the investigating officer of Nagaon Sadar PS case number 1043/23 within a period of 10 days from the date of this order. Stop. If he does so within the stipulated period of time, comma, in the event of his arrest in connection with Nagaon Sadar PS case number 1043/2023, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions, number 1 and number 2. And let this case be listed again on 2nd of February for case like.
My lord, this is a 4th application, my lord. The FIR is page number 14, my lord. 14 is long FIR, my lord. Up to 17. The gist of the FIR is that, my lord. The informant had approached the bank of the petitioner, my lord, Bandhan Bank, my lord, for a loan amount of 15,000 rupees. My lord, that gold loan against the 2 earrings claimed to be his sister's, my lord, for meeting the expense of, my lord, some emergencies. That is, as per petitioner, for payment of the medical expense of his brother who was admitted, my lord. That is not mentioned in the FIR. But, my lord, after
Who approached the bank?
the informant.
Informant.
Yes.
Who is the petitioner?
Petitioner is one of the staff in the gold loan section of the Bandhan Bank.
Okay.
But there was a previous friendly relation with the petitioner and informant. The petitioner found that the informant already an existing loan, my lord. It is mentioned in the FIR in another bank, my lord, 2-wheeler loan. So that was not paid by the informant. So he was not eligible for another loan, my lord, of 15,000 as per bank norms, my lord. But, my lord, the informant repeatedly request as on the friendship relation to the petitioner that somehow manage the amount of 15,000 I need anyway, and I will pay the medical bill. Accordingly, due to friendly relation, out of his service rule, my lord, the petitioner managed to take the loan from the bank on his own, my lord, it is admitted, own name, my lord. That is mentioned in the FIR, and petitioner also admitted that, my lord, keeping the loan earrings of the petitioner. And, my lord, the gist of the FIR that the petitioner did not refund the gold loan, and it is kept in his account, my lord. And it is also admitted he did not pay the loan amount, my lord, the informant. It is also admitted, my lord. And he wanted to refund the amount, my lord. Subsequently, my lord, on the interference of well wishers and the advocate of the informant, my lord, in the advocate's house, my lord, page number 18. A meeting was there, my lord, in the page number 18, may I read, my lord? A meeting was held that it is there is
No, no.
signature of the
Before that,
the gist that my gold was not refunded.
gist of FIR is that
Gold is not refunded, my lord.
you took gold from the informant.
Yes, my lord.
You have not returned back the
Not
gold
returned back.
earrings.
Yes, my lord.
That is the gist.
That is the
That
gist.
is the.
Okay.
That is the gist. But on page number 18, my lord, page number 18 for a moment, my lord. I have also annexed the vernacular, my lord. Both the informant to petitioners and also the advocate signature is there. My lord, we both are permanent residents of the aforesaid locality. Today on 9/7/23 about 10:30 AM, we have assembled at the residence of Advocate Ali Raja Usmani, it is advocate of informant, my lord. And on the basis of the respective documents, we came to the decision that the second party is the informant, my lord. Second party second party is the, my lord, petitioner, sorry. Second party kept the golds of the first party in his account, and rupees 15,000 of the gold with the arrear amount will be paid by the first party. First party is the informant, my lord. He will pay the 15,000, and I, the second party, that is the petitioner, my lord, with my own cost will make the gold of first party in the jewelry shop. Next, my lord, witness is the three witnesses, including the advocate. And next, my lord, gold, my lord, 11 and 7.92 gram, purity 19 carat, 18% interest of the second party, that is the bank, my lord, 15,000 for 24 months less, 1,100, which was earlier paid. He had paid only 1,100. In the remaining 18% interest he will pay, and 15,000 he will pay. Subsequently, my lord, the informant did not turn up, my lord, to pay this amount, my lord, of 15,000 with the interest, my lord. For which, my lord, his 2 earrings could not be, my lord, returned to him, my lord. That is the, my lord, case, my lord. In this, I may pray for calling the CD, my lord, if there is anything, my lord. Until the receipt of CD, my lord, he may be granted the, my lord, privilege of, my lord. He will appear, he will record his statements, my lord.
My lord, he has already said that out of relation, family relation, he has taken the gold loan and helped him. And now helping him and 18% interest, so that is, if he is not entitled for any loan, subsequently, as he is already a loan, now he has, for helping him, taken that earrings and give money. Now again demanding 18%.
Both the party, my lord, agreed, my lord. His signature is there,
Yes.
informant, my lord, in the top, my lord. Informant and petitioner signed with the, in presence of the advocate, my lord. Informant's advocate, Ali Raja Usmani, my lord. So they have already, my lord, came to a conclusion that they will settle, my lord,
Let them appear.
payment of the.
Heard Mr. M.Z. Kadir, learned counsel for the petitioner. Also heard Mr. K.K. Parashar, learned additional public prosecutor. This application under section 438 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, Ms. Baharul Haq Chaudhary, who is apprehending his arrest in connection with Silchar PS case number 2151/2023 under section 406/420 of the Indian Penal Code. Stop. The gist of accusation in this case is that one, that on date of on 10/10/2023, one Akbar Hussain Chaudhary had lodged an FIR before the officer in charge of Silchar Police Station, inter alia, alleging that the petitioner, inter alia, alleging that the informant approached the bank, approached the Bandhan Bank for securing Bandhan Bank Ranghikari branch, Ranghikari branch, for obtaining loan against deposit of gold, obtaining loan of rupees 15,000 against deposit of gold from the said bank. The present petitioner is also an employee in the gold loan section of the said bank. It is alleged in the FIR that while processing the request for loan of the said of the informant, it was found that the petitioner was not eligible for the gold loan as he had a pending loan for two-wheeler, which has not yet been settled. On this, the petitioner, who was known to the informant beforehand, offered to take loan, the loan was taken from the bank.
From the bank by the petitioner.
By the,
Take-
it is taken by the petitioner.
Yes.
Take loan.
Not by the informant.
Take loan himself and thereafter give the same to the informant against deposit of golden earring by the informant. It is alleged in the FIR that the now what has been alleged, you have repaid back the loan.
Yes, I did not refund his earrings, 2 earrings. And he did not refund the bank loan. And for which, my lord, there is a meeting, my lord, the advocate, that he will pay the loan with interest and his ring will be returned by me. That is the allegation.
No, what is the allegation in the FIR?
Allegation, my lord, that I did not return the
Return the earrings.
earrings in spite of his approach that he will pay the loan. He will pay. It is the.
Okay. It is alleged in the FIR that the present petitioner has not given back the golden earrings to the informant in spite of the assurance given by the
Yes.
informant that he would repay back the loan obtained by the present petitioner. It is submitted by learned counsel for the petitioner that the petitioner that the informant has not repaid back the loan, and therefore a meeting was in an attempt for mutual settlement was made, and a meeting was held in the residence of one advocate Ali Raja Osmani, wherein it was agreed that the petitioner would return back the golden earring to the informant, and the informant would pay to the petitioner an interest of 18% on rupees 15,000 for 24 months minus rupees 1,100, which has already been paid by the first informant. Learned counsel for the petitioner has submitted that in spite of the said mutual settlement, the informant has not approached the present petitioner to repay back the agreed amount. And therefore you have not paid, return back. the-
Return back the
Yes,
earring.
yes. He even did not pay the principal amount. It is mentioned, my lord, in this agreement, my lord. Principal 15,000 he also did not return.
It is also submitted that the principal amount of rupees 15,000 has also not been returned back. Stop. Learned counsel for the petitioner has also submitted that the dispute between the parties are of civil nature, and the petitioner would cooperate in the investigation. On the other hand, learned additional public prosecutor submits that perusal of the case diary would be necessary, hence call for the case diary, fixing 2nd February,
My lord.
fixing 2nd February for the case diary. However, considering the facts and circumstances of this case, the petitioner, namely Ms. Baharul Haq Chaudhary, is hereby directed to appear before the investigating officer of Silchar PS case number 2151/2023 within 10 days from date of this order and cooperate in the investigation. Stop. If he does so within the stipulated period of time, in the event of his arrest in connection with Silchar PS case number 2151/23, the above named petitioner shall be allowed to go on interim bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority, with following conditions. Condition number 1 and 2. Let this case be again listed on 2nd of
2nd of
February for
Obliged.
case diary.
Discussion of. 14 may be taken after some time, like Didas will repairing, after some time. My lord, in item number 15, my lord, I have gone through the, my lord, scan copy. My lord, till, my lord, the last update is, my lord, 4/11. Till then, my lord, 8 witnesses have been examined as per the status report, my lord. But my lord, copy of the, my lord, that, my lord, not in the case diary, my lord, not in the, my lord, record. Not even a single, my lord, evidence.
Is not there.
That is not there, my lord. Already 8 have examined, my lord. So we have to call for that latest evidence, my lord, and my lord, out of 12, my lord, that some more progress may be there, my lord.
None appears for the petitioner on call. Mr. B. Sharma,
My-
an additional public prosecutor, who submits that though the none appears for Jagat Likhibo, hard miss
15.
and Islam. And Islam for the petitioner. Learned additional public prosecutor submits that though the case diary is, though the scanned copy of the case record of NDPS case number 93/2021 is before this court. However, no scan copy of the
Evidence, my lord.
any testimony of witnesses is there available in the case record. And same may be required for the consideration of the instant bail application. Hence, let a requisition be issued to the learned that the scan copy is incomplete.
Yes, my lord.
So
এটাও evidence তাতে নাই, copy নাই। After already exam বলে লিখি দিয়েছে।
6 are there with me.
it is there with you.
6 were with me. I have annexed in the petition also.
Since how long you are behind the bar?
Lordship. 855 days.
What is the evidence?
That I have annexed already, Lordship. It is not.
It is in the
Up
petition.
to 6, Lordship.
Up to 6 is there, my lord, in the petition.
What is your submission?
Submission, Lordship, I'll face the trial, Lordship, and I'm not at this stage, Lordship, not merit of the case, Lordship. Only thing is that regarding the long inconsistent, Lordship, that 855 days, Lordship, that around 2 years, 4 months, Lordship. And moreover, Lordship, there are altogether 13 listed witnesses are there, Lordship, 13. And charge was framed on, Lordship, will kindly see, charge was 17/12/2021, Lordship. 2 years already gone, Lordship. There, that witness cannot be completed, Lordship, the trial proceeding. 17/12/2021 charge was framed. Any condition may be good, Lordship, for regular attendance of the trial proceeding. Regarding that merit of the case, Lordship, trial court will look into Lordship. Only my humble submission, Lordship, regarding that delay, Lordship, delay part.
Yes. You have any submission?
No, my lord, only submission, my lord, that the direction may be given to the, to expedite the trial proceeding, my lord, because already, my lord, as per status report, my lord, 8 have examined, and my lord, that is also in the month of November. So, my lord, in the meantime, my lord, some progress may be there, and all, my lord, already 13,
2 years done, Lordship.
already what has gone, that is gone, but my lord, that may be,
Yeah.
at present, it may be expedite, my lord.
Considering the other judgment passed by this court, Lordship, honorable court, Lordship, but considering that in connection to period, Lordship, that more than 2 years, Lordship. Any stringent condition, Lordship, for appearance for the trial?
Heard Mr. S. Munir, learned counsel for the petition. Also heard Mr. P. Sharma, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioner, namely N. Hawkip. Full name N. Hawkip, who has been behind the bars since 1/9/2021, within bracket, for last 855 days. That is 2 years, 4 months. In connection with NDPS case number 93/2021, arising out of Delhi PS case number 40/2021, under section 21C/29 of the NDPS Act 1985. The gist of accusation in this case is that on 1/9/2021, Manujal Gogoi, SI of police of Lahijan Police Post, lodged an FIR before the officer in charge of Delhi Police Station, inter alia, alleging that on receipt of an information through reliable sources that large quantity of heroin is coming from Manipur in a Bolero vehicle bearing registration number MN 01S 1689. 1689. No, up to till when it is updated?
It is updated, my lord, 7/11, my lord. And in that order, my lord, next date is shown as 4/11.
Yeah, Lordship, I have annexed one latest order of the court, Lordship. Lordship will kindly see a enclosure 1, Lordship, of that just now I have given, Lordship. Paging and
What is
paging. Annexer enclosure A, Lordship. I'm sorry, Lordship, paging was not done, Lordship. After the
enclosure?
enclosure A, Lordship. But
Yes,
There is a latest printout, Lordship.
next date is on 9th of,
Lordship. This is a online Lordship printout, Lordship.
Yes, that is not in the record.
Thank you.
That-
no. After that, how many witnesses have been examined?
Total Lordship, 9 Lordship,
Out of 13?
13 Lordship. I have stated there, Lordship, in the front page, Lordship will kindly see. Front, Dada, put it back.
So next date remaining 4 may be examined.
Lordship, that APR Lordship is down. Lordship will kindly see that I have break up with Lordship in the first page, Lordship. First page.
No, then we will have to wait till 9th. Because if on 9th nothing happens, we will have to see, because only 4 witnesses are to be examined. Suppose all witnesses are examined,
Hmm.
then question of bail may not arise.
For that cannot be, Lordship, and on the last occasion also, Lordship have given Lordship bail on remaining 1 or 2 like that witness also. Will appear Lordship at any condition, Lordship, because Lordship will kindly see from 20, Lordship 17/12/2021 charge was framed, Lordship. Thereafter, Lordship, till 2 years has gone, Lordship, only 9 witnesses have been examined, Lordship. That I have categorically stated, Lordship, in the first page of, just now I have supplied the copy.
Let us
Lordship.
fix it on 11th. We'll see, you report to us what happens on 9th.
As Lordship,
Heard Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor. On perusal of the record, it appears that already 9 out of 13 witnesses listed in the charge sheet has been examined, and next date of the NDPS case number 93/2021 is fixed on 9/1/2024 for
Next
evidence.
Thursday.
As the petitioner has been praying for bail on the ground of prolonged incarceration and due to delayed progress of trial, this court deems it proper to see as to what happens on 9/1/2023 in the 24 in the trial court, and thereafter consider the bail application of the petitioner. You will inform the court.
yes, Lordship, if witness is appear in the court, Lordship, then I'll try to obtain that copy, Lordship, witness copy.
Learned counsel for the petitioner shall inform about the status of the case on the next date fixed. Let this case be accordingly listed on 11th of January.
Lordship.
For bail hearing.
Lordship. Much obliged, Your Lord. Much obliged. Okay, 16, what happened, Lordship, the client has already taken away the brief, Lordship. This is the photocopy of, Lordship, the no objection certificate, Lordship. It may be kept in record, in the record, Lordship, and further my name be, maybe, which is struck out, Lordship. Direction to registration.
What will happen to this bail application?
It will like his, new council, Lordship.
In this case, my lord, it is only in my lord stage of production and copy, my lord. And the search sheet is also not in the record, my lord. Kindly that may be all for me.
Heard Mr. S. Munir, learned counsel for the petitioner, who submits that the petitioner has already withdrawn the brief from the present counsel and in support of the said submission, learned counsel for the petitioner has also furnished a no objection certificate, which is shown to have been received by the petitioner,
Brother.
petitioner's brother, namely Shah.
Mohibur Rahman, Lordship. Other three persons are there. He is the brother of Mohibur Rahman and they have engaged me, Lordship, all the three.
Learned counsel accordingly prays that name of the, you have issued, a notice has to go. No, you have informed.
No, they have
Okay.
came in a hand.
Physically.
Physically, they
Learned
have.
counsel for the petitioner has submitted that his name should not be shown in this case. Henceforth, the prayer is allowed. Let this case be listed again after a week without showing the name of Mr. S. Mani.
One more prayer. A copy of no objection may be a part of the record, Lordship, kept as a part of it.
The copy of no objection certificate furnished by learned counsel may be kept along with the record as a part of this case record. The petitioner may engage any other counsel. No, that next line is not necessary. Let this case be listed again after 2 weeks.
Because it creates some problem. If non-appearance, it becomes dismissed for default, Lordship, then it becomes problem for us. So, record. Much obliged, Your Lord. Much obliged, much.
May I please, Your Lordship, there are two items, Your Lordship. One is for bail. And another, Your Lordship, we have challenged the order spreading charge, Your Lordship, basically on the ground of, Your Lordship, lack of sanction, Your Lordship. Now, Your Lordship, it is my duty to point out, Your Lordship, that one of the case of the accused, Your Lordship, for bail, Your Lordship, that has been listed before another bench of this honorable court,
Of the co-accused.
co-accused, Your Lordship.
Okay.
And this is because, Your Lordship, did earlier that bail was rejected, Your Lordship. And along with that, there is a criminal petition also, Your Lordship, challenging the quashing, Your Lordship, and in that particular case, there is a stay order so far as the proceeding is concerned, Your Lordship.
Okay. Proceeding is stayed in that case against the petitioner of that case or entire proceeding?
That petitioner of that case, Your Lordship, but ultimately the learned court below has not been proceeded against these three accused also, Your Lordship.
Right. Same proceeding,
Same proceeding.
then this should be heard by this one court.
That's up to Your Lordship. My duty is to point out.
Because
the
otherwise there will be conflict.
conflict of judgment may be conflicted. Otherwise, I am ready, Your Lordship. And since Your Lordship, it's a question of liberty, Your Lordship. And record is in this case, Your Lordship, not in that particular case. Record has come, Your Lordship, LCR. In this particular case, two items, Your Lordship.
And there, on last occasion, Lordship, there is a question arises, Lordship, whether the process sanction has been accorded or not, Lordship.
Sanction accorded subsequent, Your Lordship. During pendency of the present proceeding, Your Lordship, sanction has been accorded. Now the question will be, Your Lordship, whether, Your Lordship, since there is a bar under section 45, Your Lordship, of UAPI Act, Your Lordship, that without sanction there cannot be any cognizance cannot be taken, Your Lordship. Cognizance taken, charge framed, Your Lordship, and at the point of while arguing
No,
on the
that has to be seen in the criminal petition.
Lordship,
That question is to be
That
answered in the criminal
criminal
petition.
petition.
But now two criminal petitions are pending before two different courts. And then there may be a conflict of judgments. There, what should we do?
And Your Lordship may probably hear the bail applications, Your Lordship.
Lordship may fix both this matter, Lordship.
Since your lordship bail is on completely on a different footing, it has nothing to do with the framing of charge, etc. Either way, your lordship.
Bail we can hear.
Lordship, believing on money is taking in the
He has not gone through the
entire because Lordship in the LCL Lordship it is some difficulties there. Lordship one page is
NCR has come in
Yes.
bail or in criminal petition.
LCL has come.
Both your
both in both
together.
Lordship. Both together as both the cases are together. Okay, zero school take a will take a Pantawari version.
Then let me pass order for listing this cases before one court.
Lords.
Registry will take appropriate instruction to which court it should go. Let it come with the other case is pending before which court?
Your lordship learned session judge, your lordship Borpeta.
No.
No, learned court number, your lordship 3.
Okay.
Honorable Justice Amar Pathak.
So
Ultimately, your lordship bail will have to be here. That bail will have to be heard by the Honorable Justice Pathak, your lordship, since it was earlier rejected during the
then
at the
it has
time
to
of
go, it
investigation
has to go there.
there. But your lordship, so far as the other bail is concerned, probably your lordship.
Bail I am keeping only.
Lordship,
The criminal petition.
lordship, that will be
In criminal petition number. The scan copy has come
lordship.
in criminal petition number, item number 37. 37 or it is item number 18.
18, 17 and 18.
Heard Mr. S. Borthakur,
18
also heard Mr. P. S. Locker, learned counsel for the petitioner and learned additional public prosecutor. It is submitted by learned counsel for the petitioner that another criminal petition arising out of same case is pending before a coordinate bench of this court within bracket Honorable Mr. Justice M.R. Pathak. And as same question is raised before in both the criminal petition, it would be appropriate if both the criminal petitions are heard by a single court. Otherwise, there may be possibility of conflict of judgments. Learned additional public prosecutor also agrees to the submissions made by learned counsel for the petitioner. In view of the submissions made by learned counsel for the both sides, let this case be listed. Let this criminal case be listed along with criminal petition number.
1105. Your lordship.
This one is 1105.
Other one is 1108 of 2023.
1108/2023 by the registry before the appropriate bench. Now, as regards bail application, heard Mr. S. Borthakur, learned counsel for the petitioner. Also heard Mr. P. S. Locker, learned additional public prosecutor, who submits that you need some time to go
Yes.
through. Who submits that who prays for some more time to go through the scanned copy of the case record before making his submissions. The prayer is allowed. Let this case be listed accordingly on
11th, your lordship.
11 January.
Deeply obliged. Which is a lordship.
matter was earlier listed before your lordship and could not be briefly recapitulate the facts, my lord. The petitioner before your lordship is a driver of a transport company, my lord, who is the logistic partner of a courier service company called Gati Kintesu, my lord.
Now, who is a,
Petitioner is a driver, my lord.
okay,
He is the driver of a transport company, my lord, who is the logistic partner of a courier company called Gati Kintesu, my lord. They transport the goods, shipment, my lord, of the Gati Kintesu courier,
Gati,
Gati Kintesu, my lord.
okay.
So, my lord, page 12 is the FIR, my lord. What happened, my lord, in this case, during the Naka checking, my lord, this vehicle was stopped by the police party. And when they stopped, my lord, they found that the container was sealed with the company lock, my lord. So they had a suspicion, my lord, and they broke the seal and found some, along with other goods, my lord, they found 2,000 bottles of cough syrup, my lord. And accordingly, my lord, I was arrested and behind the bar for last, my lord, 276 days, my lord, in this case. So my contention is that, my lord, I was just discharging my duties, my lord. It is evident, my lord, from the records that the container was sealed by the company person, my lord, and it can be opened at the destination by the concerned person, my lord. And there is nothing on record to show that the lock was tempered or there was any mischief done by the driver, my lord. So under such circumstances, my lord, there is reasonable grounds to believe that the driver is not guilty of the offense, my lord.
Okay,
My lord.
this is your submission.
This is my lord.
My lord, yes, on last occasion, my lord, yes, argued on that line, my lord, regarding conscious position, my lord. But I have also checked the, my lord, LCM, my lord. Regarding that aspect, my lord, yes, lock was, my lord, broken by the police, my lord, at that time, or at the time of checking, my lord, and it was in lock condition, my lord. Seal.
Sealed, my lord. That
condition.
lock was having the company number also, my lord, company lock number also.
And regarding that, my lord, my lord, investigation is silent, my lord, regarding that. No one has been that other person. Otherwise, my lord, yes, after that, my lord, it was found, my lord, 2,000 bottles of, my lord, cough syrup. FSL was done. FSL is codeine phosphate. And that is also there, my lord.
Who else is accused in this case apart from the driver?
My lord, only the present petitioner and his helper, my lord. But he is not the before your lordship. The helper is not before the lord.
Last order I have seen in the Malat, LCR Malat, 5/12/23, it's fiction, 18/12 for production and report. And subsequently, it is not up to date, Malat, that is the Malat latest position.
Charge sheet has not
Charge-
yet been filed.
Sashit file, Malat, Sashit on
Fine.
31/7/23. FIR Malat 3/4/23. Sashit on 31/7/23. Total 8 number of witness, Malat, in the Sashit.
Tashit, we have annexed, my lord, page 30. It starts from page 30, my lord.
And last order in the LCA Malat, 5/12/23 Malat. It is fixed for production and report on 18/12 next day. But subsequent is not. But regarding that aspect, Malat, yes, Malat, one I have phlegma, Malat, I have earlier phlegma one
You
statement.
have
of the-
any authority?
My lord, there is a very similar circumstances, my lord, where coordinate bench has granted
Hey,
in my lord.
LCA data. Accused statement on the. One statement of the accused. Just,
Paragraph 4 is very. Paragraph 4, sub clause 4 in this order,
Word.
my lord,
But this case was of investigation stage.
investigations.
But in your case, charge sheet has been,
Charge sheet has been filed, my lord.
something has been found against you.
My lord, page 38 of the charge sheet, my lord, if your lordship may kindly peruse. During investigation also, my lord, they did not find anything, my lord, which suggests my complicity in the present case.
What,
What-
pa-
Page 38, my lord, from 14, 15.
where,
My lord, clause 16, brief facts of the case, then my lord, the third paragraph, my lord. The body of the truck was locked with orange color bolt seal lock. The bolt seal lock was broken to open the container body of the truck. After broken, that is, my lord, during investigation, my lord, there was nothing on record to suggest that the lock was physically tempered, or the petitioner has, my lord, some sort of, or the petitioner has done some mischief, my lord.
yes, Mr. Parash.
My lord, may I once go through the statement of the accused, my lord, just I have taken, my lord, as per the statement, my lord, owner of the truck gave him, my lord, directed to deliver that goods, and he loaded this items, my lord, I have taken the statement of the accused.
CD is there.
Yeah, scan copy, yes. Scan copy of the CD.
Okay, I'll go through it. Any other submission?
My lord, my submission is that I was
You
just
are not in conscious possession of the
exactly, my lord.
seized
Seize
contraband.
contraband, madam. Had there been any sort of material suggesting that the lock was tempered,
Now, what was the allegation in the charge sheet against you?
it was the same malady of the FIR, madam. That they stopped the vehicle, they found it in
2000 bottles of.
sealed condition, that was broken, that was the malady,
But you don't know what was being carried.
madam.
Heard, Mr.
Yes, my lord, the statement of
That
the
is the
driver, my lord,
submission.
Yes.
This is item number, heard Mr. M.H. Chaudhary,
20, my lord.
M.H. Chaudhary, learned counsel for the petitioner, also heard Mr. K.K. Parashar, learned additional public prosecutor. Let this case be fixed for delivery of orders on 12th January.
12th January. Madam, regarding the statement of the present petitioner, I have also got copy, madam, where he stated that I had no idea there were a cup syrup loaded in our truck.
The petitioner stated,
Petitioner statement, madam, I had no idea.
and you are behind the
But-
bar since 700 and
No, madam, I'm behind the bar for 276 days. I was arrested on forwarded on 3/4/2023, madam.
But as per the direction of the owner, the whether owner is doing business or.
whether investigation, whether it was investigated, that aspect was investigated. If
is
that was not
very clear,
investigated,
madam.
they may get benefit.
That is not very clear.
That was nothing.
12/1,
Yes, madam. Madam,
11/1
madam,
on 11th January. Amita,
madam, owner was not major accused in this case, madam.
okay, I'll go through the
Yes.
material.
But another, madam, Dorikram, the kind of series, madam,
My lord, I hope today no adjournment will be sought. Because there has been prayer for adjournment on the last 4 occasions, my lord.
Lordship, time being Lordship, kindly pass over the matter for timing.
Very difficult to do cases with NCB. Your lordship will see how many dates adjournment was taken in this case.
No, they are not seeking adjournment. Only accommodation. We'll take it up at 2.
Lordship on second. Okay, Lordship.
At 2.
Lordship, another matter is fixed at 2 in court number 21. So on second, Lordship.
Okay. We have to hear them.
Absolutely, my lord. My lord, I'm not, it is, my lord, it is only delaying the entire proceeding, my lord. This man is behind the bar for 2 years and 5 months.
We'll hear it today. We'll hear it.
My lord, let her, she may inform us when her senior will be free, my lord, because otherwise it will be
At 3.
at 3 o'clock.
Let-
Okay, Lordship. Much homeless.
I'm taking a short break.
Side was signaled to stop by UBC so of the Naka party, and the vehicle was stopped at the Naka checking point and conducting checking as per routine. During checking, 50 numbers of packets of suspected to be ganjas were recovered from the said truck. The driver of the truck, namely Irfan Khan, so and Muhammad Rizwan, so was detained with the help of the Naka checking party, and the information was immediately reported by me to the officer in charge Bazarichara PS and superior officers about recovery. During the spot interrogation, the driver and helper of the said truck could not give any satisfactory reply about the ganjas. At about 7:30 p.m., I saw authorization letter for search and seize the suspected NDPS items to CI Ramakrishna Nagar Sri Deepak Das, Inspector of Police. And I received the same at about 7:45 p.m. from Ramakrishna Nagar through WhatsApp. After receiving the authorization letter, I served 2 separate notices under Section 50 of NDPS Act and started to search the narcotic substances about his right to be searched in presence of independent witnesses. However, they could not be taken to nearest magistrate or gazetted officer for search, as there was every likelihood that they would destroy the drugs or throw away which was suspected to be concealed in their vehicle. As such, the whole process was carried out in accordance with 55 of NDPS Act and 100 CRPC. Now, Lordship may kindly see my two folded submission here. First, that the search and seizure was conducted at 7:10 p.m. and this was not a public carrier, Lordship. Only husk was there, husk bag was there, and it was not accessible to public. Lordship, and second, my point is, Lordship, that 50 subclause 6 is not complied here. That they have not made the search seizure in presence of gazetted officer while conducting body search, and even they can search the body in absence of gazetted officer, but similar to section 42, they have to inform the superior officer within 72 hours within section 50 subclause 6.
From where the ganja was recovered?
It was recovered from the truck. And if during Lordship that search they search my body, then also section 50 will be attacked. I will rely on judgment, Lordship.
Okay.
If during other search, Lordship, if they do body search, then section 50 will attack.
But suppose ganja was not recovered from your body.
That
It
is
was
different,
recovered
but
from elsewhere.
yes,
Then whether violation of 50 would have any material impact?
Lordship, I will place that judgment.
Okay.
And now, Lordship, may kindly see section 42. 42 proviso, last part.
Yes.
Provided further that if such officer has reason to believe that a search warrant or authorization cannot be obtained without affording opportunity for the concealment of evidence or facility for the escape of the offender, he may enter and search such building, conveyance, or enclosed space at any time between sunset and sunrise after recording grounds of his belief. So that grounds has to be recorded. And here, Lordship, his grounds is that it may be concealed, and it is, Lordship, the quantity Lordship will find at page 14. It is 231 kg. He cannot throw it or he cannot conceal it. And now, Lordship, section 43, Lordship may kindly see. It is regarding, Lordship, that power of seizure and arrest in public place. Now, whether my case falls under this section or not, Lordship may kindly see that explanation part.
Yes.
Explanation
Yeah,
for the
section.
43. Explanation for the purposes of this section, the expression public place includes any public conveyance, hotel, shop, or other places. Now, this is important, Lordship, intended for use by or accessible to the public. I was not carrying any public transportation, Lordship. No goods, public goods was carried by me. And it was not accessible to the public. If public transportation bus is there, then I can understand.
No,
It
this
was,
heavy goods carrier truck
Lordship.
was not a public carrier.
No, it was not accessible to public and it was not used by public. So that I am stressing on the word, Lordship, intended for use by or accessible to the public. So therefore, my case will not fall under section 43, Lordship. And now, Lordship, kindly turn to section 50.
Yes.
Section 50. When any officer duly authorized under section 42 is about to search any person under section proviso. So first 1, 2, 3, 4 was there initially, Lordship. That prior to this, Lordship, that Baldev Singh's case was there. That in 1999, Baldev Singh's case was the constitution judgment is there by Honorable Apex Court. That it is mandatory. That subsequently what happened, Lordship, after that constitution bench of Honorable Apex Court, the central government incorporated subclause 5 and 6 in the year 2001. And your Lordship will find in down below that inserted by Act of 2001 by 22 with effect from 2/10/2001. So after Baldev Singh's case, Lordship, this section was incorporated. Now, Lordship may kindly see subclause 6. After a search is conducted under subsection 5, the officer shall record the reason for such belief which necessitated such search and within 72 hours send a copy thereof to his immediate official superior. So here under this section also they have to send the copy to immediate superior officer.
Okay.
So now I am placing for Lordship whether section 50 will attract in my case or not. Just placing one judgment. This is by Calcutta High Court, Lordship, relying on Honorable Apex Court judgment that your Lordship will find paragraph 7, page 7, Lordship. Page 7, designation is at top, Lordship.
Yes.
That in bold it is there, Lordship, got it down below. The state of Rajasthan versus Permanent. Lordship got it. The Apex Court inter alia held as follows. Paragraph 15. If merely a bag carried by a person is searched without there being any search of his person, section 50 of the NDPS Act will have no application. But if the bag carried by him is searched and his person is also searched, section 50 of the NDPS Act will have application. So here my truck was searched. Apart from that, my body was also searched, which is admitted in the FIR itself. In the light of the aforesaid declaration of law, I hold section 50 applies to the search conducted by the NCB official in the present case. Now, Lordship may kindly turn to page 10. After discussing everything, Lordship, that after quoting first paragraph, recovery of narcotics
No, here the bag was carried by the
by the accused.
accused, carried in his hand.
carried in his hand.
But in your case, it is carried in the vehicle.
No, the question is,
Your
Lordship,
case, the quantity of ganja is 231 kg.
yes,
So it was not carried by the person.
no, that is.
Now
that-
my query is,
Lordship,
suppose 50 was not followed
Lordship,
and body check was done. Nothing was found in body check.
Lordship,
The contraband was found elsewhere
Lordship,
in the vehicle.
Lordship.
Then whether violation of 50 would be material or not.
Yes, that is why I'm referring to page 10.
Page?
Page 10.
Yes. Yes.
After discussing all this section 50, that recovery of narcotics, Lordship, got it? Recovery of narcotic from a bag carried by a person would attract section 50 of the NDPS Act if in course of such search, the body of the suspect has also been searched. There is ample evidence on record that a body search of the appellant has also been undertaken where narcotic was recovered from a bag carried by the appellant. Why so and so? Failure to comply with section 50 in course of such search vitiates the seizure of the consequential conviction. So my submission to your Lordship is that although nothing was recovered from my body, but the during Lordship that track search, my body was also searched. So therefore, section 50 will be attracted in the present case.
And if 50 would be attracted, your
Attracted.
submission.
Then they have to show that whether 50 subclause 6 is complied with or not.
And if it is not complied with,
Then mandatory provision is not followed.
then you will get benefit of
Yes,
it.
benefit of-
Though do you have any authority
Yes, Lord.
that you will get benefit of bail,
Yes,
that 37 may be overcome?
yes. Paragraph 7 of the journal. Paragraph 7.
This bag and vehicle does not, the analogy of,
No,
Fine.
initially, Lordship, there was proposition that if during search, body search, nothing was recovered and it was recovered from bag, then section 50 will not be applicable.
if, no,
That is-
that is if the person is carrying contraband in the bag,
Lordship,
which is carried by the petitioner.
Lordship.
In your case, that is not the case. In
Yes.
your case, there is no bag.
Lordship,
The huge quantity of contraband is found
Lordship,
in the vehicle.
Lordship. But the proposition
So
is,
that analogy of bag,
Lordship.
whether it would be applicable in this case.
but my submission for Lordship is that the bag and the truck, but although it was carried in his hand, but it was recovered from the bag, not from his personal possession, Lordship, from his body. It was recovered from outside his body. So it is recovered from bag or truck that outside his body. That is my submission to your Lordship. Now, paragraph 7, Lordship may kindly see. It is pertinent to note that in the bail application of the appellant, it was alleged that there was serious violation of section 42 of the NDPS Act. In the impugn order, nothing is stated about the alleged violation of section 42. And it is observed that it was not necessary to consider such violation at this stage. The compliance of section 42 is mandatory, and what is a relevant fact which should be engage the attention of the court while considering the bail application. In the aforesaid circumstance, having regard to the aforesaid, so it was he was granted bail, because mandatory provision was not followed.
So if there is violation of 42 also, you will get benefit.
So my two-folded submission, first 42 was not complied and 43 will not attract in my
How
case.
42 was not complied by noise?
Because
not
after sunset,
Sunset
after
and
sunset,
sunrise.
Okay.
In between.
in between.
In the night,
And-
it was.
It was night. And second, that body search was conducted and it is admitted in the FIR that he was not taken to gazetted officer. And if that is not, then they have to comply with section 50 subclause 6, that they have to send a copy with reasoning why they have conducted body search without in absence of gazetted officer within 72 hours. So whether that copy is sent or not, that
Yes, Mr. Das.
My lord. So far submissions made by my learned friend are concerned, my lord, those are not based on facts and truth. Because my lord will find GD entry number 196. This is a GD entry which shows the police team went out for regular Naka checking. It is not that they had any specific information regarding carrying of drugs by him. This was an ordinary Naka checking. And recovery of drugs is a chance recovery. They did not have prior information. Therefore, violation of section 42 or 50, all this doesn't come. And your lordship will be more clear if your lordships go through the subsequent GD entry number 202. I have flag marked it, my lord, for your lordships. He immediately informed the gazette officer, CI of the police station, my lord, who issued authorization letter to him for carrying out search and seizure. That authorization number is, my lord, also given here in the GD entry. Immediately he informed, came back to police station after recovery, then made GD entry number 202. Everything is, my lord, noted down here. So violation of 42 doesn't come, and it is a chance recovery.
So 42 comes only when
When there is
there-
prior
there is a
permission, then
prior
only question of, yes, there
prior information.
prior information, if specific information is there, that they are going to search a particular premises or particular vehicle. Therefore, my learned friend has to satisfy your lordship that whether in the case of chance recovery, all these things apply.
According to you, this is a case of chance recovery.
Chance recovery, absolutely chance recovery. No specific information.
Okay.
Your lordship will go through the, make your lordship clear. These two GD entry only.
Any other submission?
No, there is no
So
violation of
There
section.
there is,
Well, after getting authorization letter, the proviso of section 50 says that if it is not possible to obtain authorization, he has to record reason. But in this case, authorization letter is there. And the case is progressing, already, I hope four PWs have been examined, my lord. A question of bail doesn't arise, my lord. And my lord, I have gone through the PWs, my lord. My lord, independent witness has also, my lord, supported the seizure. My lord. So everything is there, it was
Sir Ahmed,
seized from him.
do you have any counter submission regarding chance recovery?
chance recovery, lordship, may I see that 42 subclause to once again, okay?
Yes.
Here it is written, lordship, that where an officer takes down any information in writing. So it does not say, lordship, that whether it is prior information or it is
No, any information in writing under section clause 1.
one.
So
Yes.
clause 1
Clause
speaks.
one here also, lordship will find, just I am reading again once. Any such officer, being an officer superior in rank to a peon sepoy of the Department of Central Excise, Narcotic, Customs, Revenue, Intelligence, or any other department of the central government, including paramilitary forces or armed forces, as is empowered in this behalf by general or special order by the central government, and any such officer being an officer superior in rank to a peon, sepoy, or constable of the revenue, drugs control, excise, police, or any other department, said government, if by special, so I am skipping this, if he has reason to believe from personal knowledge or information given by any person and takes down in writing that any narcotic drug or substance in respect of which an offense punishable under this act has been committed, or any document or other article which may furnish evidence of the commission of such offense, or any illegally acquired property or any document or other article which may furnish evidence of holding any illegally acquired property which is liable for seizure or freezing of forfeiture. So here, in my understanding, Lordship, that prior information is not exactly the meaning, Lordship, because here, this sentence I am again reading, Lordship, if he has reason to believe from personal knowledge or information given by any person.
No, there are judgments on this, in this line,
Lordship.
when there is chance recovery and when there is recovery on the basis of an prior information.
Lordship. But that proviso, Lordship, proviso,
Yes.
after provided further that if such officer has reason to believe that a search warrant or authorization cannot be obtained without affording opportunity for the concealment of evidence or facility for the escape of an offender, he may enter the search a building, conveyance or enclosed space at any time between sunset and sunrise after recording grounds for his belief. After recording the grounds of his belief.
So this, according to you, second proviso
Second.
is
proviso.
applicable even if there is no prior information.
Yes.
And even if the search is made of
Made.
a vehicle
Very good. That they have to
After
record the
sunset.
reason.
after sunset.
Yes. That's why they are conducted in between after sunset and before sunrise. And that 50 subclause 6, whether it is complied with or not, that is there.
Okay, I'll go through it.
That GD entry will suffice me, not it.
Two GD
196 and 20. Do I have that one?
heard Mr. A. Ahmed, learned counsel for the petitioner. Also heard Mr. B. Sharma, learned additional public prosecutor.
Das.
Sorry, D. Das, learned additional public prosecutor. Let this case be listed for delivery of orders on 11th of January.
Obliged.
To step up the step.
Your lordship, it is pending trial and LCR is before your lordship. Your lordship will kindly see that he was arrested on 22/1/2023. And the charge sheet we have annexed, lordship, will kindly come to page number 20, which is very important, lordship. Here, what has happened? Pending FSL report, the charge sheet has been filed. Now, the matter is fixed, lordship, on 10th of this month for examination of the MO and the IO. But basically what happened, the IO intimated the honorable court, honorable trial court, that he has got the FSL report, but the copy he submitted that was forwarded and addressed to the Assistant Commissioner of Police. So the court did not accept. Court said, no, you filed a supplementary charge sheet, as you have written down here. So I would pray if this matter again comes up on 12th, lordship, 12th of this month. 12th, and by this time maybe MO and IO will be complete. Otherwise, lordship, if on that day MO and IO cannot be taken, I will press for the bail, lordship, because why, lordship, I am submitting, he is there on 22/1/2023, more than, it's going to be 1 year, he is behind the bar. So only because the IO is unable to.
On behalf of respondent number 2,
My
the
brother is
informant father, we have filed objection.
Objection today. I've just received it right now, lordship. So I will.
This is a case, NDPS case.
No,
No,
the
lordship,
POCSO.
under POCSO,
Oh,
POCSO.
under.
POCSO, lordship.
Okay, okay.
section 6.
Section 6 of the POCSO Act.
Then
So-
let us fix it after 12.
On 12th, if your lordship kindly.
After 12.
Yes, please.
It is fixed on 12th in the.
No, 10th. 10th it is fixed.
Okay,
That is why I'm praying for 12th if your lordship kindly accommodate, lordship.
okay.
Because on 10, if the IO again make the same mistake, it doesn't bring those reports, then lordship, I'll press my bail.
Heard Mr. A. Bhattacharya, learned counsel for the petitioner. Also heard Mr. S.K. Sarkar, learned counsel for respondent number 2, as well as Mr. K.K. Das, learned additional public prosecutor.
In
learned
the
counsel,
meantime, Lordship, we may submit our reply if your Lordship allows us. My brother has given a reply, if at all required, we may,
learned counsel for the petitioner submits that the sessions special case number 54/23 is fixed before learned trial court on 10th
10,
of
1, 24.
2024, on which date the court has summoned the medical officer as well as the investigating officer. Learned counsel prays for fixing this case on 12th, that is after examination of the IO and
M1.
MO. Learned counsel also prays that he may also be allowed to submit a reply to the objection filed by counsel for the respondent number 2. The prayer is allowed.
Deeply.
Let
Highly
this case be listed again on 12th of January.
Highly obliged, Lordship.
AG Reserve Dutta Hussain. Chamber. Yes,
The 439 application Lordship, case diary was called for. Page diary receipt. And the FI Lordship will find on page 8 Lordship, the typed out copy.
since when you are behind the bars?
Lordship, I am behind about 26/11 Lordship. 36 days Lordship. Till direct involvement is not there Lordship, they only.
What is the allegation?
May I read the FI Lordship?
Yes.
Page 8. Most respectfully, I beg to inform that I am so and so, that yesterday, that is on 14/11/2023 at about 10 p.m. While I, along with my drivers, namely Sri Jintu Das, was returning from Gotanagar after closing my shop situated at Gotanagar. At that moment, two miskin came by motorcycle compelling us to stop my vehicle at Nachari. Thereafter, three miskin who were aged about 22 to 25 years with arms stepped out from a black Wagoner car which was already parked there. While they were heading toward us, out of fear, my driver turned the vehicle and somehow managed to flee away from the situation and rushed to Gosu police station. On seeing this, the three miskin attacked the window pane of my vehicle with arms. However, they could not break the glasses, window pane, and therefore we somehow saved our life. And it is important to mention that one miskin was on motorcycle. His complexion was fair and healthy, and he was wearing a white spec. And he says Lordship 22 to 25 years Lordship, but the present petitioner Lordship, they are 35 years and 30 years Lordship, that the person and the ground of arrest Lordship. The ground of arrest on page 19 Lordship. Ground of arrest, page 19 Lordship. The reason for arrest, the arrested accused were found involved with this with the miscreant Lordship. They were not there Lordship, but involved says. During the course of investigation, it is found that the arrested accused are frequently contact with the miscreant who were present at the PO at the time of incident. During the course of investigation, primary evidence has been found against the arrested accused. If not arrested, they are not. But it is clear from the forwarding report, Lordship, that they were not present at that place of occurrence. Only Lordship, frequent contact was there. Maybe for other reason also, Lordship, contact may be there.
How many accused are arrested?
Till now, 3. However, the most of the prime accused, my lord, there are 3 prime accused. They were still absconding. However, in this case, if I look into the FIR Lordship, one Wagoner's name is there Lordship. And at the time of the commission of the crime, one of the evidence is there Lordship, one eyewitness is there. He have recorded the whole incident, my lord. And on that account, my lord, this Wagoner number has been received, my lord. And when it has been searched, investigation is gone, my lord. Then one Mansur Ali's name, in that name, Lordship, the Wagoner has been registered. On in further investigation, it came to know that the Mazanil Hawk was in possession of that car, Lordship, vehicle. And he has named this for how the entire incident took place. It has been stated there. But another important point is there.
one vehicle, motorcycle's name is also there. However, this motorcycle and the vehicle, that Wagoner, is found in this person's house, Lordship. Mazanil Hawk, Lordship. And the motorcycles in the motorcycle, Lordship, number plate is not there. And there in the statement, they have stated that one, this Lordship, Alamuddin, he gives this person, Zahir, he used to make this duplicate documents of this vehicles, my lord. And both of them had also stated that they were involved in car lifting activities, Lordship. So in case of 392, any kind of assistance comes under it, Lordship. Because in the attempt, many more things are there, Lordship, in 392. Attempt is also there. Provided facilitation is also there, Lordship. In 392, if I look into the section, facilitation is also there. So the vehicle that has been provided, Lordship, which is not, number is not there. So investigation is going on. It is at a crucial stage, Lordship. So at this stage, it is not.
No, what materials are there that they are involved in
Lordship,
fake, making fake documents? of
392, Lordship. In the case of 392, one vehicle is there, which is present at the time of commission of the crime. It is their bike. They have also confessed, not
How
confessed.
they are
they have
connected
stated.
with the bike?
Because in
present-
that bike, my Lordship,
Present petitioners.
Lordship, in the bike, there is no number plate. And they were also involved in this lifting of these vehicles, Lordship. So investigation is going on that line. And moreover, the main accused persons, they were not still absconding, Lordship. And they are still communicating with this person, Lordship.
Inside the jail, Lordship.
They are communicating, Lordship.
Inside the jail, Lordship. Lordship, it is assumption, Lordship, that robbery, Lordship, no attempt was there, Lordship, because they did not came contact with them, Lordship. They only signaled to stop, Lordship, as per the allegation of the FIR, Lordship. The Black Wagoner, Lordship, came near them, they fled away, Lordship. What is the case, Lordship? The informant can only say, Lordship, that's fact.
You put the flag, Mr. Das,
Lordship,
in the case diary, wherever there is material against them,
Lordship,
flag it
Lordship.
and give it to me during
Lordship.
lunch. I'll dictate it at 2.
Lordship, and one more thing, Lordship, the Lordship, page 22 and 23, Lordship, is the employee, Lordship, of the post office, Lordship, that the petitioner number 1, Lordship, the Zahir Ali, Lordship. That is,
Because they are behind the bar since last 36 days.
Lordship, I
So
understand.
sufficient time for collecting evidence against them.
Mhm.
So what evidence is there against that you find out
Lordship.
and flag it?
My lord, my simple line of argument is that only, my lord. Investigation is going on because these persons are veteran criminals, Lordship. So
So
it makes
suspicion is there.
Lordship.
Apart from suspicion,
My lord, there is reasonable
no,
suspicion.
you go through the
Lordship,
case diary.
reasonable suspicions, Lordship. Because
36
investigation is
days,
still going on,
36
Lordship.
days are sufficient, is sufficient time.
Lordship. I
You
will
go
flag it,
through.
Lordship.
I'll dictate at 2.
Lordship. Much obliged, your Lordship, much obliged.
Yes, Putul. Next item.
May I please, your lordship.
CD not available, Lordship.
Section 12 of the POCSO Act is the lordship.
Okay, CD would be required.
Case of 2019.
When will you produce? This is a charge sheeted case,
No, lordship.
pending investigation.
Yes, lordship. Since 2019.
And when you are behind the bar since,
No, lordship, this is AB.
or AB,
Yes, lordship.
so since 2000,
2019, the FIR was lost, lordship.
so you are not arrested.
No.
Then why are you apprehending arrest?
Now, lordship, I am apprehending. Police is searching me now, lordship.
Case diary would
Lordship, may
be,
kindly come to,
no,
yes,
case diary would be required.
may I appear?
12 January, Lordship. 12 January.
Yes.
12
From
January,
Golakganj, Lordship.
will it be possible? or take it after Bihu?
It
Let
will
it
be
be on
sufficient, but
Because
18,
January.
heard Mr. M. Ahmed, learned counsel for the petitioner, also heard Mr.
I hope.
I.
I hope.
I Hawk, learned counsel for the
Respondent number 2.
respondent number 2, as well as Mr. K. Das, learned additional public prosecutor, who submits that though the case diary was called for, however, same has not arrived, and prays for some more time for producing the case diary. Prayer is allowed. Let this case be listed again on 18th January.
Highly obliged.
FR submitted, Lordship.
এই আগৰ কেছটো CD এবাৰত দিব লাগে তেওঁ চোৱাৰ পিছত
FR submitted.
FR submitted. You were on interim.
I was on interim.
FR submitted, that means it becomes infractious.
Yes, yes.
Heard Mr.
B.
B. Bora, learned counsel for the petitioner, also heard Mr. K. Das, learned additional public prosecutor, who submits that though the case diary was called for, however, in the meanwhile, the investigating officer has submitted the final report in this case, bearing final report number
172/23, dated 31/10/23.
in view of submission of the final report. This anticipatory bail application has become infructuous and accordingly disposed of.
Make the lordship. Pass over for the timing, my lord. My senior will appear for the time.
My pleasure, Lordship. This is 438 application, Lordship. And FI will find page number 10, Lordship. Translated copy, Lordship, and the petitioner is a
This is matter under POCSO Act.
Lordship, POCSO 8, Lordship, and in this case, Lordship, and one more time already gone, Lordship, and the 4 dates already gone, Lordship, and step has been taken. And my lord, and the petitioner is a second year science student, Lordship, and upcoming exemption will be started.
No, you have taken steps as per.
Steps. My lord, I have appeared on behalf of the respondent number 2, my lord.
Okay.
On last
Got it.
yesterday, my lord, I have submitted the correspondence.
Okay, now the service part is over.
Service complete, Lord.
Now what is your submission? Now we can hear it. Yes, make your submission.
Lordship, may I read the FIR, Lordship?
Yes, there is there.
Case diary is there.
Lordship, may I read the FIR, Lordship, first?
Yes.
Page number 10 and translated copy. With due respect, I beg to state that on 29/9/2023 at about 1 p.m., the accused number 1 with a pretext to domestic work called my minor daughter, namely Afsana Khatun, aged about 15 years, to his house and tried to commit physical relation with her. And while my daughter escaped and my daughter-in-law, namely Kushana Parvin, go ahead and then the accused fled away by leaving her. Therefore, in this regard, I informed the guardian and the accused number 2, 3, and 4, seeking justice. Accordingly, they agreed, but in the same day at night about 10 p.m. above named accused person forcefully entered into my house and rebuked us with filthy languages, me along with my family members, and also threatened us with dire consequences if I shall lodge any FIR before the police station in this regard. So, my lord, and only one line is there, Lordship, and the petitioner was trying to commit physical relation with the victim, Lordship. But I have very clearly, very specifically mentioned in my petition, para number 4, and they are the relatives, Lordship, and adjacent house, and there is the land dispute regarding a small road, Lordship. And the one road is using by the petitioner and the informant parties, Lordship, since long back. And the land is belonging to the father of the petitioner. And this road is closed and they have diversion the road in another way, Lordship. And for their domestic purpose, Lordship. In this regard, Lordship, and there is a land dispute is going on. And subsequently, and he is only the son of his family and he is pursuing his study, Lordship. And he is the science student and is a second year student lordship. Only for destroy his career lordship, this FIR has been lost lordship. Otherwise, there is nothing happened, any such type of incident in the house of the petitioner lordship, that because they are the almost same courtiers lordship. And the 18 years, 5 months boy lordship, and he's a bad career and science student, and his examination will be start from lordship. I have given the lordship program lordship of the examination schedule lordship. And so my lord, and POCSO 8 is there, not committed anything is happened, lordship. Just 18 years boy lordship.
What material
164 statement is there, Lordship.
she
164
has implicated?
implicated, Lordship. Moreover, Lordship, one IO has given in the note also, and bail objection, in the bail objection, one thing I will point out, my lord. It has come to know that the accused person have been threatening to victim, Lordship. And her family, after granting pre-arrest bail to other persons, an order to withdraw the petition, otherwise will harm, Lordship. So threatening is there, one angle is there, Lordship. Implicated, my lord may look into it. 164 statement, my lord.
Lordship, threatening part is their lordship, and what is this lordship? And there is the proceeding lordship, 107 proceeding may be brought against the petitioner, but lordship and so what type of lordship? That is the allegation lordship, and that because, and if the honorable court is appreciate lordship, and otherwise lordship, there is another fact will come. Really making case lord. An incident took place on lordship and 29/9 lordship. Not 29, sorry. 19/9 lordship, 19/9 lordship, and they have lost the FIR. 22 lordship, after 3 days lordship. There is nothing mentioned in the delay reason.
Yes.
That part only, Lordship.
My lord, so far my instruction is that, my lord, the other accused persons, they have obtained pre-arrest bail from the learned court below, and thereafter they are threatening the informant, my lord. That part is only there. That instruction is only there. And on the other hand, my lord, the learned friend.
Under such circumstance, how will you get anticipatory bail if you are threatening?
Lordship, so those person, those who are granting bail by the learned court below, they are threatening lordship. I am not at home lordship. I am outside lordship. That because I am a student lordship. How then what a 18 years old boy lordship? And as per the FIR lordship, and the
Investigating officer has submitted a report, objection, my lord, in the form of objection, my lord, that these accused persons, the other accused persons are threatening. That means, and also threatening, and also asking the informant to withdraw this case. Report is there, my lord.
These are the lordship, the common things, lordship, and it is happening in the society. And
No.
lordship,
This is not a case fit for grant of bail.
what is the involvement of the petitioner lordship?
I'll go through case diary, but likelihood that your prayer for anticipatory bail would be rejected.
Lordship, only for considering the career lordship, and he's a second year student, and his examination will start from 12th science student lordship. Only that part lordship may be considered lordship. Otherwise, section 8 is there, and lordship, if there is any threatening lordship and they have not filed any complaint before the IO or SP lordship, superintendent of police, either DC for the draw of the 107 CRPC can be draw up against the petitioner. There is the alternative way, lordship.
Okay, I'll go through the case diary.
Lordship, considering the lordship and the age and the career of the student petitioner, only 18 years just completed, and there is a second year student
Consider
lordship.
everything. You have any other submission?
And lordship, only lordship, and suppose he is arrested lordship, and everything will not settle lordship, and they are the same family.
What has been done? What is alleged in the 164?
160 plus. That's
The POCSO is also come, Lordship. As per 164, I have already submitted. Lordship.
No, section 8 offense. Section 8 is specific. When sexual assault,
Section 8.
he has to touch specific areas.
He has
Lordship.
implicated that the accused has tasked her cheek.
Cheek, yes.
Lordship.
In the 164
Lordship.
statement.
Now whether touching cheek would be,
No, Lordship. But I will.
would be covered under section 8 or not.
Intention.
The learned counsel for the petitioner who prays for fixing this matter after vacation on the ground that her senior is not aware who is the conducting counsel of this case. Learned counsel for the opposite party does not opposes the prayer, only with a rider that a date may be fixed. Considering the submissions made by learned counsels, the prayer is allowed. Let this matter be listed again on which date you want.
22nd, 21st, and 23rd.
23rd January.
Much effort, sir.
Item number 12 and 13.
Yes.
I am ready with the case, but my learned friend is saying that I should do my part, thereafter they will. I think together we should do the case.
Yes.
One part I do, then thereafter they do it.
It will be
Again, I have
difficult for
rebuttal.
me also.
That becomes difficult. So I told your lordship that we the next day, any date which is inconvenient after the view vacation.
Heard Mr. D. Das, learned senior counsel, assisted by Mr.
M. Moore.
M. Moore, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor who submits that he needs some time for preparing the case before he makes his submission. The prayer is allowed. Let this case be listed again on which date you want.
Listed question. Somewhere after vacation, it's like 23rd is Tuesday.
30.
30th also. No, I will not be 30 or not difficult. Yes. 30 is Tuesday. Nahi? ठीक है sir.
On
30th.
30 January.
Interim order will
The
continue. both the cases.
interim order shall continue till next day.
Yes. So what, let it be on the safer side in the month of February somewhere, because already
February first week, second week, first week.
after 4th of February, any date, it's 6 days, 6 Tuesday, 6
6th February.
Replay.
Item 23.
Heard Mr. S. Munir, put a CD. Case very good. Heard Mr. S. Munir, learned counsel for the petitioner. Also heard Mr. K. K. Das, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed by the petitioners, namely Joher Ali, alias Jahir Ali, and Ali Muddin Ahmed, who are detained behind the bars since 26/11/2023, within bracket for last 36 days in connection with Jalukbari PS case number 672/2023 under section 392, 511/34 of the Indian Penal Code. So the gist of accusation in this case is that on 15/11/2023, one Rohini Kumar Chaudhary lodged an FIR before the officer in charge of Jalukbari police station, inter alia, alleging that on 14/11/2023, at about 10 p.m., when the informant, along with his driver Jintu Das, was returning from Gotanagar after closing his shop situated at Gotanagar, two miscreants came on a motorcycle and compelled them to stop their vehicle near nursery. And thereafter, three other miscreants who were aged about 22 years to 25 years with some arms stepped out of a black Wagoner car and headed towards the first informant. It is further stated that first informant somehow managed to fled away from the scene. However, the three miscreants attacked the window pane of the vehicle of the informant. Stop. Learned counsel for the petitioner has submitted that the petitioners, both the petitioners are aged about 35 to 36 years and are no way involved in the offense alleged against them in the FIR. Learned counsel for the petitioner has also submitted that the petitioners are already detained behind the bar since last 36 days, and considering the period of detention, they may be allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of Jalukbari PS case number 672/2023 and has vehemently opposed the grant of bail to the present petitioners on the ground that both the petitioners, there is evidence on record that both the petitioners are involved in preparing fake documents of stolen vehicles and are connected with the vehicles which are also involved in this case. That is the Wagoner and one motorcycle which was found without any number plate.
No, only motorbike. Only motorbike.
Motorbike which was found without any number plate. Learned counsel for the petitioner has also, learned additional public prosecutor has also submitted that there is also evidence to show that one of the co-accused whose statement was recorded has stated that the present petitioners were in contact touch with the miscreants who are yet to be.
In CDR details, according to CDR details.
According to CDR details, they are in constant touch with the miscreants who are yet to be arrested. Stop. I have considered the submissions made by learned counsel for both the sides and have perused the materials on record. Including the case diary of Jalukbari PS case number 672/2023. Though learned additional public prosecutor has opposed the grant of bail to the present petitioners. However, on perusal of the case diary, it appears that at this stage of the investigation, there is no direct evidence against the present petitioner regarding their involvement in the offense alleged in the FIR. Though there may be strong there may be ground to suspect their involvement in some manner in the alleged offense. However, same may not be sufficient to justify any further detention, considering the period of detention they have already undergone, that is 36 days. Under the above circumstances, this court is of considered opinion that further custodial detention of the present petitioners may not be necessary for fair completion of the investigation in this case, investigation in Jalukbari PS case number 672/2023, if the petitioners cooperate with the investigating officer. In view of above, the above named petitioners are hereby allowed to go on bail of ₹30,000 each, with one surety of like amount, to the satisfaction of learned
CGM Kamrup
Chief Judicial Magistrate Kamrup Metro
at Guwahati.
and Guwahati, with following conditions. Condition number 1 and condition number 2. With above observation, this bail application is hereby disposed of.
Much obliged, sir. Much obliged. Much obliged.
Heard Mr. F. Hawk, learned counsel for the petitioner. Also heard Mr. K.K. Das, learned counsel for the learned additional public prosecutor, as well as Mr. J. Hussain, learned counsel appearing for respondent number 2. This application under section 438 of the Code of Criminal Procedure has been filed by the petitioners and by the petitioner, namely Soriful Islam, who is apprehending his arrest in connection with Goroimari PS case number 94/2023 under section 376/511/448/294/506 of the Indian Penal Code, read with section 8 of the POCSO Act, 2012. The gist of accusation in this case is that on 22/9/2023, one Azibur Rahman had lodged an FIR before the officer in charge of Goroimari Police Station, inter alia, alleging that the accused number 1 named in the FIR, that is the present petitioner, on 29/9/2023 had called the minor daughter of the informant to his house and tried to commit physical relationship with her. And when the daughter of the first informant screamed, the daughter-in-law of the first informant screamed, the accused fled away from that place. It is also alleged that the other accused persons named in the FIR, that is accused number 2, 3, and 4 mentioned in the FIR, who are the relatives of the present FIR, have threatened the first informant not to lodge any FIR in this regard. Learned counsel for the petitioner has submitted that the present petitioner is a young boy of 18 years of age and is a student of higher secondary final year examination, and his examinations are scheduled to be held from February 12, 2024. It is also submitted by learned counsel for the petitioner that the allegations leveled against the present petitioner in the FIR are false and is a result is a conspiracy hatched by the family members of a conspiracy hatched by the informant, as there is a land dispute between the family members of the present petitioner and the first informant. Learned counsel for the petitioner has also submitted that the petitioner would cooperate in the investigation if he is allowed to go on bail. On the other hand, learned additional public prosecutor has produced the case diary of
Goremari PS
Goremari PS case number
94
94/23
/23.
and has vehemently opposed the grant of anticipatory bail to the present petitioner at this stage, submitting that there are implicating materials against the present petitioners in the case diary, including the statement of the victim made in the FIR. On the other hand, Mr. J. Hussain, learned counsel for respondent number 2, has also opposed the grant of bail to the present petitioner on the ground that the other accused persons named in the FIR who are already allowed to go on anticipatory bail are threatening the victim and her family not to pursue the matter any further. I have considered the submissions made by learned counsel for both the sides and have perused the materials available on record, including the statement of the victim girl recorded under section 164 of the Code of Criminal Procedure. The petitioner is a young boy of 18 years of age. And if we look at the statement made by the victim girl under 164 CRPC, the only allegation leveled against the present petitioner by her is that the petitioner had held her hand and touched her cheek, and nothing else was done by the petitioner, as he fled away thereafter on the shouting of the victim girl. Under such circumstances, stop. Under such circumstances, considering the statement of the victim girl and the implications made by her against the present petitioner, and also considering the fact that the present petitioner would be appearing in his higher secondary final examination from 12th February 2023, this court is inclined to give the benefit of anticipatory bail to the present petitioner with certain conditions. In view of above, the present petitioner is directed to appear before the investigating officer of Goremari PS case number 94/2023 within 10 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, he shall be allowed to go on bail of rupees 30,000 with one surety of like amount, subject to the satisfaction of the arresting authority with following conditions. Condition number 1, 2. Condition number 3, the petitioner or his family members shall not in any manner threaten the victim or his family member. And any violation of this condition may be a good ground for cancellation of bail granted to the present petitioner. With above observation,
There is one small correction is there, Lordship, in the FIR that this incident took place on 19/9/2020, but I have there is typical error 22/9. So it may be corrected and the order is also
Incident occurred on 19/9/2020.
But I think around 22. 29. I may be correct. 29, sorry, 29.
What I have dictated, 29.
No, 20,
Instead of 29/9, it is 19/9.
19, Lordship. Published, published. Published.
Right, please, Your Lordship. This appeal is directed against the judgment and sentence passed by a learned special judgment. Annexure G is.
We are admitting the appeal.
Yes.
and issue. Heard Mr.
D. Bodo.
B. Borwa, learned counsel for the appellant. This appeal is preferred under section 374 of the Code of Criminal Procedure by the appellant, Shri Vikas Fukon, impugning the judgment and order dated 23/12/2023 passed by learned Special Judge Sorai Deo in Special P case number, special within bracket P case number 58/2016, whereby the present appellant has been convicted under section 4 of the POCSO Act, 2012, and has been sentenced to undergo rigorous imprisonment for 7 years and to pay a fine of rupees 50,000, and in default to undergo simple imprisonment for 1 month. Issue notice to the respondents. As learned additional public prosecutor has appeared for respondent number 1, no formal notice need to be issued to respondent number 1. As regards respondent number 2 is concerned, the petitioner shall take steps as per the mode prescribed in the case of Deepak Nayak versus State of Assam by a division bench of this court within 3 days from the date of this order. Let the case record of special within bracket P case number 58/2016 be called for from the trial court. This appeal is admitted for hearing. It is mentioned. Let this matter be listed accordingly after 4 weeks.
Published.
May I please, Your Lordship. Lordship, here in this case, Lordship, the petitioner is a registered owner of a truck, Lordship, and truck is seized by the police. And subsequently, Lordship, and he approached to the learned court below, Lordship, but the learned court below was rejected his prayer. And it will find on page number 17, 13%. Lordship. And the order is reflect that the learned court below having no jurisdiction to grant jimma. On that basis, Lordship, the prayer is rejected. Page number 17, Lordship, and the second para.
So the court below is right because there is a judgment of
Lordship, and I have the judgment, Lordship, in this case, that is Ram Kumar Mora versus Lordship, and in this case, Lordship, and just I am relevant para, Lordship, page number 45.
Okay. There is a judgment of this court, single bench judgment where
And Lordship,
which was
all the order, Lordship, and case is reflected in this case, Lordship, and common order has been passed. And 11 portion para 45, Lordship. 457 and 451 is in 45 last para, Lordship.
okay.
In view of the reasons stated above,
Which para?
45. In view of the reason stated above, we answer the reference by holding that the investigation stage seized articles cannot be released by the court under section 451 CRPC. However, under section 457 CRPC, the criminal court has jurisdiction to give custody seized property articles at the stage of investigation when those seized property are not produced before the court. So, my lord, already and 102 CRPC, that is the power is vested upon the police, and 457 is their lordship. There is no bar lordship, and there is the provision of Panchanama. And the subsequently, if there is any required, and the Panchanama is executed. So, my lord, and he is the registrar owner, otherwise he will be suffered.
Or on earlier occasion, 12/12/23, a report was called for whether a vehicle is required for investigation or not. That we have not received.
And as per the order lordship, there is nothing mentioned. Whether
is
I have
mentioned, yeah.
submitted any report or not, nothing. But only learned court below observation is made, having no jurisdiction. That part is mentioned.
No, আমার একটা case of
কি লাগবে? try করতে হবে।
investigation with order report লাগবে না আমার পুলিশ অফিসারে কি করে
সম্ভবত তো একটু কয় নাই, silent আছে।
আমি তো কোর্টের কোশ্চেন
It has jurisdiction when the property is not produced before the criminal court. In your truck has not been produced.
Lordship, seizure list is made, so
See, only seizure list reported, it is reported, but it has not been produced. So jurisdiction is there.
otherwise lordship, the track for purpose will be served.
No, I'm not on that. I'm on law question. Question of,
I believe so.
the trial court, let us read the judgment order of the trial court.
Yes,
Operative.
page number lordship, and start from 16.
This judgment of the division bench is reported in, whether it is a reported judgment.
Lordship, and reported
In
perhaps lordship.
where,
not
where?
I went to there, I have to be another.
ফটো দিয়া নাই ফটো দিছে ফটো দিছে গাড়ীখনৰ
একটু বাইরে পুলিশ স্টেশন আছে।
গাড়ীখনৰ ফটো দিলে তো হ'ব এইটো প্ৰডিউচাৰ হ'ব
থানা পাশে ইয়াতে পুলিশ পুলিশ
Heard Mr. F. Hawk, learned counsel for the petitioner. Also heard Mr. K. Das, learned additional public prosecutor. This application under section 397/401, read with section 482 of the Code of Criminal Procedure, 1973, has been filed by the petitioner Kabatullah Khan, impugning the order dated 22/11/2023, passed by learned Judicial Magistrate First Class Rongya, Kamrup in Baihata Sareli PS case number 347/2023, whereby the prayer for, where is the impugn order at page
Page number 16, lordship,
16?
16.
Whereby the prayer for jimma of a vehicle seized in connection with the aforementioned case was rejected by the learned Judicial Magistrate First Class Rangya on the ground that under section 457 of the Code of Criminal Procedure, a criminal court does not have jurisdiction to give custody of seized property / article at the stage of investigation when those seized property are not produced before the court. Stop. Learned counsel for the petitioner has submitted that the vehicle bearing registration number WB 4558 58 within bracket Ashok Leyland 3718 BS4 belonging, you are the owner,
Lordship.
belonging the owned by the present petitioner was seized in connection with the Bahata Sareli PS case number 347/2023 on which date?
Lordship, 8/11/2023.
On 8/11/2023. And since the date of seizure, it has been lying, where it is lying?
Police station. Lordship.
At the Bahata Sareli police station under open sky. Learned counsel for the petitioner has also submitted, you have submitted your registration certificate,
Lordship. Submitted.
has furnished the registration certificate of the said vehicle to show his ownership over the said vehicle.
Lordship.
Learned counsel for the petitioner has also submitted that the learned judicial magistrate first class Rania had erred in observing in the impugn order that under section 457 CRPC, the criminal code does not have the jurisdiction to give the custody of a vehicle if it is not produced before the court. And in support of his submission, learned counsel for the petitioner has cited a ruling of this court, cited a ruling of division bench of this court in criminal petition 284/2022 within bracket likable, State of Assam and another versus Ram Shankar Maurya, wherein the division bench dealing with similar other petitions had disposed of a number of criminal petitions by order dated 2/3/2023 and has held as follows. Quote paragraph number 45 from the judgment. Stop.
And others as well, Lordship. Sundarbhai Ambalal Desai, Lordship.
Where is that judgment? Sundarbhai Ambalal is there with you.
Lordship.
On the other hand, learned counsel for learned additional public prosecutor has submitted that there is no report from the investigating officer as to whether the seized vehicle is required for further investigation or not. Stop. I have considered the submissions made by learned counsel for both the sides. The apex court in the case of Sundarbhai Ambalal Desai versus State of Gujarat reported in 2002 10 SCC 238 has observed as follows. Quote paragraph number 17 from the judgment. Stop. In view of the observation made by the apex court in Sundarbhai Ambalal Desai within bracket Supra, there is no use of keeping seized vehicle in police station for a long period. And it is for the magistrate to pass appropriate order for granting jimma of the said vehicles. Further, in view of the judgment of the division bench in State of Assam versus Ram Shankar Maurya Supra, it also appears that under section 457 of the Code of Criminal Procedure, the criminal court has the jurisdiction to give the seized property / articles at the stage of investigation, even when those articles are not produced before the court. In view of the aforesaid observations made by this court in the above noted case, the observation made by learned judicial magistrate first class Rongya in the impugn order does not hold good and needs interference by this court. Stop. Accordingly, the impugn order dated 22/11/2023 is hereby set aside, and the learned judicial magistrate first class is directed to consider the prayer of grant of jimma by grant of jimma of the seized vehicle to the present petitioner in the light of judgment passed by the division bench of this court in State of Assam versus and another versus Ram Shankar Maurya Supra. With above observation, this criminal revision petition is hereby disposed of.
Obliged, Lord. Obliged.
My lord, lordship would recollect, I made my submission. Our basic case was, my lord, in the selection process, the present petitioner was at the relevant point of time additional superintendent of police headquarters. He was not even associated with the selection process. If lordship would recollect, if lordship kindly comes to page number 27 of the 24 of the petition. Just briefly point out that. Just to recapitulate the, my lord, facts.
Yes. Yes, page
Yes,
number.
page 24, my lord. The police headquarters constituted district level selection committee for recruitment of constables. Now, this was the order 24/12/14. Now, if lordship would kindly come to page 27, serial number 18, Nagaon district. Aurobindo Kolita IPS, Arnab Deka APS, one senior medical officer to be nominated by the Director Health Service Assam. So, my lord, these are the 3 persons who were entrusted with the recruitment process as far as Nagaon district is concerned. Now, please come to page 29, my lord. Last but one para. The district level selection committee will be fully responsible for implementation of the said guidelines in letter and spirit. After completion of all tests, etc., state level police recruitment board will approve the select list of the candidates for appointment as per existing rules. All papers and digital records will remain in custody of the superintendent of police of the concerned district. Similarly, all equipments and computer hardware, etc., procured and used during process will remain in the custody of the concerned SP under a proper inventory. The Range Inspector General, Inspector General of Police, Deputy Inspector General of Police will act as co-opted member of the state level police recruitment board within the range and will ensure proper implementation of the rules and guidelines. So, my lord, this OM or office order clearly laid down the guidelines for selection and who all are the person who are responsible for making recruitment. Now, at the relevant point of time, I was neither superintendent of police, I was nor a member of the committee. Therefore, my lord, the allegation against the petitioners cannot be countenanced. Now, if your lordship will kindly come to the FIR at page 22, what is the allegation?
Yes.
With due respect, I beg to state that based upon news item published in different local newspaper regarding malpractices adopted in recruitment process of AB Constable in the year 2015 in the district of Dhubri, Borpeta and Nagaon, a discreet inquiry was initiated and conducted from the side of the Vigilance and Anti-Corruption Assam. And after preliminary inquiry, regular inquiry was initiated at the instance of the government approval dated so and so by forming an SIT headed by Superintendent of Police, Vigilance and Anti-Corruption and other members including myself. SIT on regular inquiry, it is found that below noted persons under a criminal conspiracy have made wrong manipulated records instead of free and fair interview by abusing their official position for their wrongful gain and thereby committed criminal breach of trust and cheated in the process of recruitment of AB Constable in the district of Dhubri, Borpeta, Nagaon and submitted its finding to the Assam government. Accordingly, government was pleased to order by dated so and so to register a criminal case against the below noted persons. Now, if lordship will kindly come to page 23, serial number 4, kindly see Hitesh Roy, the then Additional Superintendent of Police, Headquarters, Nagaon. Now, my lord, in the affidavit filed by the authorities, my lord, if your lordship will kindly come to that affidavit filed by one Pinak Prasad Mitra, I think he was the IO, my lord. Now, para 8 of that affidavit.
Written objection.
Yes, written objection.
Yes.
Para 8 at page 5. For that, after discreet and confidential inquiry conducted by Sri Karuna Bordoloi, he submitted his finding as Sri Hitesh Roy, Additional SP Headquarters, was the leader of collection group and had collected huge amount of money from 100 to 115 members of candidates at the rate of so and so from each candidate. Again, in the report submitted by Chairman SIT after conducting regular inquiry, it was found that 15 number of police officials, personnel including the present petitioner, were involved in large-scale malpractice and that occurred during recruitment process of AB Constable in the district of Dhubri, Nagaon, Borpeta. So, my lord, the basic allegation was petitioner was a member of the gang that had taken money from the recruitees. Now, my lord, I can appreciate, my lord, if this information emanates from some statement given by somebody under 161 or some statement given by somebody under 164. Then it will inspire your lordship's confidence. But it can't be on the subjective satisfaction of somebody or the IO. It must be based on some material. Now, which are the material? In your affidavit, you have not disclosed anything. That is why lordship wanted to know the records, the CD.
CD
what
would disclose.
My lord?
Treasury would disclose.
Yes, Treasury would disclose what is the basis. Now, if it inspires the lordship's confidence, then here is a case that I should face trial with defendant. Unless prima facie, my lord, other than subjective satisfaction, because lordship will kindly appreciate one thing. This SP, Mr. Aurobindo Kolita, I must enter into some conspiracy with him if I am to do, I am to get some benefit out of this wrongdoing. If he does not agree with me, if I don't conspire with him, how, my lord, the wrongdoing can be done? So there is no allegation that there is a conspiracy between the chairman or member of the selection committee and the present petitioners. Why people will pay money to us? Unless, my lord, I have some understanding with the
No, but suppose you have, assuming that you have collected money from the
recruitees.
recruitees,
Ah.
telling them that I will help you in your recruit.
That is not their case. No, my lord, end of the day, it has to withstand the test. The end of the day, my in trial, what will happen, my lord? Why should I face this ordeal? Now, if the CD reveals that what has been stated in paragraph 8 is based on some cogent material, some
Someone
material,
has stated that I paid money.
I paid money. There is nobody has come forward to give any complaint. And my lord, in 3 districts it happened. This is not even specific which allegation pertains to Nagaon, which the allegation pertains to Dhubri, which allegation pertains to Kolkata. These are all general statements, my lord. So therefore, my humble submission is, unless, my lord, this, and my lord, kindly see, this statement has been verified as true to the knowledge. Please come to the affidavit portion of the affidavit, my lord, at page 8. Page 8,
Yes.
para 10. That the statements made in para 1, 2, 4, 5, part 8, 9 are true to my knowledge. Now, please disclose the source of your knowledge. Therefore, my lord, probative value of materials reflected in affidavit in opposition cannot be gone into by this honorable court. And secondly, my lord,
Unless it is backed by some material in the case list.
my lord will kindly apply the test. So when charges are framed, the guideline is given in 227, 228, my lord, lordship will find out whether the allegation taken in its face value and the materials which have been brought out without considering what would happen after cross-examination, whether it can lead to a charge or not. If that is there, is okay. But that is not even there. At least it is not reflected in the affidavit. So that's my humble submission, my lord. I have clearly stated that there is no material at all. If somebody's statement under 161 is there, somebody under 164 has during the course of investigation said something, that is not even there. At least it is not indicated in the affidavit. Therefore, in my humble submission, my lord, the continuance of the proceeding is an abuse of the process of law, my lord. Some inspector, my lord, some discreet inquiry, this is not permissible, my lord. End of the day, when you set in motion a criminal law, there must be some fundamental basis. I'm a government servant, my lord, because of the pendency of the case, my promotions have been held up. My batchmates have been promoted. So therefore, my humble submission is, subject to what reveals from the CD, my lord, I think it's a fit case or lordship will cause the proceedings. I reserve my right of reply subject to what my learned friends submit.
Now the investigation has been stayed.
Yes.
Stated in respect of.
Only
In respect of one.
petitioner,
Okay.
not the whole case.
But otherwise, investigation is on.
In this, in one another case also, stay order is there.
Now,
There are-
how it can be stayed in respect of petitioner? Suppose while investigating,
But investigation is going on,
while investigating for other petitioners.
Then also if something,
I collect some materials
then
against.
also it can matter. Then also, provided it is there, my lord.
Okay, yes.
কার কথা পড়িলে
আমি-
করুণা বড়লে
নহয় নহয় আমি কৰোণা
এই
পিনাক
এইখিনি
পিনাক মিত্ৰ
আৰু করুণা বড়লে
কৰোণা বৰদলৈ কৰোণা বৰদলৈ ইনকুৱাৰীটো কণ্ডাক্ট কৰিছিল।
yes. My lord, that Corona Bordole statement is there, my lord, in the case diary. It was it is a short statement, not very long.
No, you make submission first.
No,
Korna
the
Bordole
response-
is the IO.
My lord,
Korna Bordole is the
the
IO,
IO.
who has also shown the,
That discrete inquiry was, my lord, made by him.
so whether,
And thereafter SIT was done. In report of the SIT as well as his report, my lord, petitioner's name figure. And Corona Bordole says, it was also learned that Sri Hitesh Chandra Rai, APS, the then additional SP headquarters Nagaon, was the leader of the collection group and collected huge amount of money from
No,
100 to
that is
150.
the
It is
submission of,
land.
that is the submission of the. learned
Exactly. No,
counsel.
that is, no, what, I cannot improve the record.
No,
my lord.
is there,
This is the part of case diary.
no, is there anything in the case diary which reveals?
Now, my lord, I have gone through uh, statements of other witnesses. Other witnesses means, my lord, some police personnel who were, my lord, performing duty during the course of, my lord, physical efficiency test. Now, some candidate, some such police personnel says that he was doing duty for 2 days. Thereafter, he was removed, and some other person was brought. These things were there, but they say that we did not notice any anomaly during the course of this physical efficiency test. Now, one candidate statement was recorded. He says after interview, physical test, he claims that he did very well, so he should be selected. When he was taking tea in a tea stall, 3 persons were talking about bribing for the job. He says there are 3 other persons. In his statements also, this petitioner's name does not figure. They were talking, they were trying to bribe somebody, but he doesn't know. So direct payment, I did not find here.
No, my query is,
My lord.
SIT said there was an SIT form.
Yes, yes.
It conducted an inquiry.
Inquiry.
It submitted a report that during the conduct of inquiry, we found materials against following persons, including the present petitioner.
Yes.
Now, what material were found, whether that is revealed or not?
That is not there. Only report is there.
Basis of that report has.
Only report, not the materials collected by them is not there. Only report is the part of the case thing.
Then how will we verify?
That is the problem, my lord.
Is there any material or not? Whether material,
Yes, I understand, my lord. In such case, my lord, there must be some direct evidence that yes, this candidate paid money to so and so X, who is an agent of this petitioner.
the inquiry report is there.
Inquiry report is there. SIT report is there. Discrete report is there. Discrete inquiry report.
Now, in SIT report, the basis of the finding is there or not? The finding is there that we find that he
This,
is involved.
in some video footage report is, my lord, examined by them, and they say that, my lord, anomalies were detected
Involving the present.
in the recruitment process.
Now, whether petitioner's involvement is there or not?
That is what, my lord. Direct statement I have not found.
Indirect statement is there.
Indirect statement that the
That
Corona Laboratory says
observation-
that he learned. But I do not know where from he has learned.
Okay.
Well, I may submit the case there, your lordship, my parents. I have flag mark. So whatever I thought.
You have flag
important-
mark it.
Whatever I thought, my lord, important.
Okay.
Well, I think my learned friend submission, I don't think I'll have to give any reply. To set into motion a criminal law, something more is required.
And case is pending for my lord since
My
2016.
lord, my promotion has been held up.
Charge sheet is yet to be filed.
Now, what happened to other persons named in the affair?
No, I am examining so far he is concerned,
Because
my lord.
there are,
Since he is before your lordship, my lord, I
To
tried to find.
my knowledge, my lord, charge sheet has not been filed in any of the case. To my knowledge, subject to correction. I don't know what case that it is.
Mainly 3 districts, my lord. Dhubri, Borpeta, and my lord, Nagaon.
My lord, sometimes these newspaper reports are correct, sometimes not also. my lord. So therefore, to rely solely on the newspaper report may not be always correct, unless it is corroborated by some chosen materials.
And subsequently, the interview was cancelled, my lord.
Cancel.
so your submission is that why it should be quashed? Number one.
Number one, my lord, there is no material to connect me with the alleged offense. Because I was not a member of that committee who was entrusted with the task of making this election.
And though SIT names you,
No, but that is only subjective. Maybe somebody said something that's wrong. There is no 161 statement, there is no 164 statement. Had there been, and there is no allegation by any aggrieved candidate that we paid money to so-and-so, we did not get the job. There is no allegation. And my lord, I was additional SP headquarters. I was not interested with the selection. The selection committee was headed by SP, and SP has never been charged. Because until and unless the SP, my lord, who is the chairman of the selection committee, conspires with me, I don't think I can deliver the goods, even if the allegation is taken to be
Is
correct.
there-
No, he is not
whether SIT report is there? on
Yes,
the
Yes,
code?
yes, it is there.
What it says?
Then again, my lord, subjective, you learned,
District-wise, some analysis is given below.
learned. Whether that learned is enough, my lord. That is why, my lord,
we are-
in
we are-
that Pepsi food products case, where Honorable Supreme Court says, merely because a magistrate can discharge, that does not mean a high court, either under 226 or under 482, cannot quash the proceeding. I think I relied upon that while opening my argument, my lord. Just,
Which cases?
yes, my lord, I'm giving that, my lord. 1998, 5 SCC, I'm giving the copy, my lord. My lord will kindly come to paragraph
Now
28.
now one query is there.
Yes, my lord.
The case is still at investigation stage.
Yes,
You have been named in the FIR.
maybe,
Some allegations are leveled against you.
yes.
Now, why we should not wait till completion? The
No,
quashing of FIR will be done only if there is no material in the
No, my,
FIR.
no, my lord. Whether it's true, investigation qua the petitioner was stayed by this honorable court. Now, as my learned friend has fairly said, my lord, that in respect of others also, though investigation is progressing, nothing has, followed to implicate me. He says one candidate was examined, he says he had never implicated me. Video footage has revealed some anomaly regarding physical efficiency test, where my role is not attributed. So virtually, my lord, the investigation is on, or rather, nobody has interdicted the investigation. Now, if your lordship will kindly permit me to place this paragraph, my lord,
Yes.
para 28 and 29. Summoning of an accused in a criminal case is a serious matter. Criminal law cannot be set into motion as a matter of course. It is not that complainant has to bring only 2 witnesses to support his allegation in complaint to have the criminal law set in motion. The order of the magistrate summoning the accused must reflect that he has applied his mind to the facts of the case and law applicable thereto. He has to examine the nature of the allegation made in the complaint, evidence both oral and documentary in support thereof. Would that be sufficient for the complainant to succeed in bringing charge home to the accused? It is not that the magistrate is a silent spectator at the time of recording of the preliminary evidence before summoning the accused. Magistrate has to carefully scrutinize the evidence brought on record and may even himself put question to the complainant and his witness to elicit answers to find out the truthfulness of the allegation or otherwise, and then examine if any offense is prima facie committed by all or any of the accused. No doubt, magistrate can discharge the accused at any stage of the trial if he considers the charge to be groundless, but that does not mean that the accused cannot approach the High Court under Section 482 or under Article 227 to have the proceedings quashed against him when complaint does not make out any case against him, and still he must undergo the agony of a criminal trial. And look, here it's a case of complaint. Here is not a case of a complaint, but it's an FIR. My lord, FIR makes some certain, my lord, bold allegations. Bold, assertions. Well, bold assertions are not supported by any material. At least the case diary does not reveal anything, my lord. Now, though the investigation, Kwame was not undertaken, but as a whole, the investigation was undertaken. And that investigation has not revealed anything to implicate the petitioner. In that view of the matter, I'll humbly submit, my lord. I
No,
mean,
your relief is for quashing the FIR,
qua the petitioner,
quashing the FIR.
FIR.
But FIR alleges certain, makes certain
My lord,
allegations. against-
FIR may allege, because kindly see, my lord, what is the basis of the FIR? He
Freedom-
believes, he has information, that's all.
Okay, now, no, my.
Now kindly see the FIR's language, my lord. Now I'm prepared to answer each and every query of your lordships, my lord, kindly
No,
see.
let me put my query first.
Yes, my lord.
FIR has been lodged by Pinaki Prasad Mitra.
Yeah, and he has filed the affidavit,
He has filed.
filed the affidavit.
But the investigation is done by some other IO.
No,
He is not the IO
no, I think he's the IO, my lord, 1 second.
because the
No,
person.
he, affidavit, I'm the. He has not described himself, but I understand he's the IO, my lord. He has not described himself.
Informant is himself the IO.
I think so, yes, my, I'm discharging my inspector vigilance power being. It will check me.
Because your state in Pepsi food,
Yes,
the question is different.
no, there it was a complaint, where if the complaint does not reveal anything. Here, my lord, there is no material, only kindly see the FIR. FIR does not,
No,
FIR speaks
here
of an
I
SI.
want to understand one thing. Here you are named as an accused.
Maybe, my lord, merely
Al-
because,
No, let me put my question.
Yes.
You are named as an accused.
yes,
After investigation, the IO may not find anything against you. He may
Yes.
file an FR. Then
no, what I'm trying to submit for lordship's kind consideration is, my lord, that investigation is going on, though not against me. My lord, it's not that when they will investigate, they will only try to find out my role. As a whole, they have found out. What has emerged overall, that does not, I mean, implicate the petitioner. That's what I think my learned friend has indicated. If there was something wrong in the physical efficiency test, then I was not there. I was not a party in the physical efficiency test. Some candidates' statements recorded, they do not implicate me. Then where are the materials? Lordship has, my learned friend has read out that sentence of that Bordoloi. He says he has reasons, he has information. What is that information? Can, my lord, based on some information which is behind my back, my lord, a criminal law can be set into motion? Yes, if he could have said, I have taken statement of so-and-so candidate under 161, he has directly said that I have taken money from him, then it's a different thing. That is not there, my lord. Merely because my name appears, that by itself may not be enough. Because subsequent investigation has not revealed anything. Thus, you will kindly appreciate that. And what is the basis of the affair? Please see, have a look, my lord.
now what are the circumstances under which an FIR may be quashed?
My lord, an affair can be quashed. Yes, first of all, my lord, as laid down by the Honorable Supreme Court in Bhajanlal, there are series of situations. Now, one of the main reason is, my lord, if the affair prima facie does not disclose an offense.
That is not there in this.
Not
case.
there.
No. Here it is disclosing.
No, affair does not disclose anything. Kindly see. Kindly come to the affair, my lord. That's why I was trying to read it. SIT on regular inquiry, it is found that below notice under a criminal have made a wrong manipulated records instead of free and fair by abusing their official position for their wrongful gain and thereby committed criminal breach of trust and cheating in the process of recruitment, so and so, so and so, so and so. Now, are these not very vague and general statements, my lord? Now, what is that cheating I have done? Whom I have cheated? Who has been cheated? Who has alleged before the authority that I have been cheated?
That will be found during investigation.
The investigation has been done, nothing has been revealed. I'm trying to submit, my lord, the investigation which has been carried out by them up till now has not revealed anything. Though, my lord, Kwame, it was stayed. It does not mean, my lord, the investigation was stopped. Investigation proceeded. That's why till that they have not filed any charge sheet. I quite appreciate what has fallen from your lordship, my lord. But lordship will try to make out an exception. Yes, my name appears in the FIR. There has to be some basis. What is that basis? Am I in charge of selection?
No, then you are answering the question. On what ground FIR may be quashed?
FIR may be quashed, my lord,
It does
amongst others on the ground that it is an abuse of the process of law also. This investigation, if it is permitted, it will lead to an abuse of the process of law. That is also one of the ground enumerated in my lord Bhajan Lal's case.
Which one?
Yes, my lord will have this. I brought Bhajan Lal also. Yes. Kindly come to that usual 107, my lord. Paragraph
Yes.
102.
Which clause?
Now it will be covered by subclause 1 also. Then, my lord, 7, where the criminal proceeding is manifestly attended with malafide or where the proceeding is maliciously instituted an ulterior motive for wreaking vengeance on the or with a view to spite him with due private and personal grudge.
Then you have to show that some enmity was there between.
My lord will kindly come to 5. Where the allegation made in the affair or the complaint are so absurd and inherently improbable, on the basis of which no prudent person can ever reach a just conclusion that there is sufficient ground for proceeding against the accused. My lord, I am not in charge of this selection. There is no allegation that the members of the selection committee and we conspired. There was a conspiracy. There is no allegation. The chairman of the selection committee is not even accused. So, my lord, why a candidate will pay us money unless we can offer them a job? And to offer them a job, I must join hands with the members of the selection committee. So 5 will be attracted. Will it not be an abuse of the process of law indirectly, my lord?
No, whether 5 would be attractive.
Yes. Where allegation made in FIR, it is improbable. Yeah, where is the allegation in the FIR or even in the subsequent, if the investigation
The SIT report, it is there.
SIT report based on what? He believes. SIT report is not based on any statement of any aggrieved person. My learned friend has read out that portion of Corona Bordello, my lord. He thinks this has happened. Can criminal law be set in motion merely because Mr. Korunakanta Bordello believes that there was something wrong in the recruitment process?
So your main emphasis is on clause 5 of.
5. It is inherently improbable, my. I think that in no, same. In Somdat also, my lord, same thing was said.
Otherwise, the general law is court would be very reluctant.
Very slow. will sparingly Lordship will exercise. Court never said, Supreme Court never said High Court will not exercise, but will sparingly exercise. At the end of the day, my Lord, Lordship will also take note of the probative value of the materials which are contained in the CD. Whether those materials can lead to any, my Lord, consequence under the criminal law. If yes, then certainly Lordship will not allow this petition. If Lordship comes to the conclusion these materials cannot form the basis of proceeding in a criminal case, certainly Lordship will interfere. I'm making a very dispassionate and impartial argument, my Lord. Why it is said, my Lord, while framing charge, the court will take note of the probative value of the evidence, materials on record. They don't use the expression evidence. At that stage, it is materials. That's why I'm repeatedly making this submission, my Lord. If SIT's view would have been based on statement of some persons given under 161 or 164, yes. There is none.
SIT report is furnished to you also.
No, madam. Not
It is there in the case diary.
it is there.
You have flagged it.
Yes. That SIT's report, which is the basis for the FIR, if the SIT's report is based on some cause and material, which has some probative value, then it's a different matter. If it doesn't have, then why will your lordships allow? That's what in Pepsi Food Products Supreme Court has said. Merely because a magistrate cannot discharge or police can submit an FIR, why should I face an ordeal, my lord? I'll have to appear before the IO again and again. They will record statement, this and that. So lordship will take note of all these
No,
aspects.
In Pepsi, only discharge has been
No, what I'm
discussed.
saying is, my lord, be it discharge, be it, well, quashing of an FIR is a concept which is not abhorrent, my lord. It is, yes, the law is it has to be done very sparingly. Normally, my lord, police investigation
So I
cannot
have
be
to
state.
come to a finding that it falls under exception.
Except, correct.
Only then I will exercise my
Yeah,
jurisdiction.
absolutely correct. Your lordship will have to come. That's why I'm making that submission for lordship's kind consideration. The materials which CD reveals, whether those taken in its face value as it stands, without, any cross-examination, whether it can lead to anything. If it can, yes. If not, lordship will give me that benefit. I think that is the law, my lord. Be it, allowing them to proceed further, or be it, my lord, allowing the court below to, my lord, frame charge. That is my humble submission.
Subject to your lordship's permission, my lord. One reply I may permit to visit, subject to what my learned friend says. My lord, my learned friend says that he was additional SP, he was not part of the selection committee. But your lordship will kindly note that he was occupying the post of additional superintendent of police, which is an influential position in the district. So he had that influential position. So that, because he was not a part of the selection committee or interview board, my lord, that cannot negate that, my lord, he cannot be bribed by anybody. So he had the position to, my lord, influence the members of the selection committee also, my lord.
And lord, if
So-
there is any evidence or materials that somebody gave me bribe, then it's okay. Whether is any. When the allegation is I was the chief collector, then at least when I'm the chief collector, it is so much widely known. Then at least somebody should have come forward and said, yes, I paid so and so money to so and so. If that is there, end of the matter. If that is not there, my lord, then
But that would be done only during investigation.
investigation has been done, my lord. That's why I'm making my submission, my lord. They have proceeded with the investigation. Not Kwame, generally they have proceeded with the investigation.
But due to this theater, he could not be interrogated.
No.
Yes, sir. His
He-
documents were.
My lord, I will not implicate myself. Let us be very pragmatic about the whole thing.
I'm submitting the case there, your lordship.
I will not implicate myself, my lord, nor
I think.
the law also protects me from that Article 20, sub-Article 1.
Okay, I am reserving the judgment.
Fine.
I may have some queries.
My lord,
Mr. K. N. Chaudhary, learned senior counsel assisted by Mr. D.S. Teka, learned counsel for the petitioner. also heard Mr. D. Das, none in additional public prosecutor. The hearing concluded, judgment reserved.
Deep level.
I hope date is not fixed.
No, I'm reserving the judgment.
Oh, that's a lordship's prerogative.
I'm keeping case diary with me for few days.
Mal. CD in court number.
Deep level.
15 number.
NCB is not there.
My lord, will kindly give me a right of audience, my lord. Today I want to make submissions, my lord, because I am literally answerless to my clients. 4 adjournments before the High Court and 20 adjournments.
What
before
has
the-
happened?
Lordship, he is still on legs in court number 21 for part-time matter. He's there.
NCB must have more than one standing
That's
counsel.
the entire issue, my lord. That's the entire issue, my lord.
Therefore, because lot of cases are pending here.
My lord. My lord will kindly allow me to make submissions, my lord, because the 4
But
days,
I have to hear NCB.
my lord,
I
will,
may hear you.
my lord will, because my lord, 2 cases, similar cases, my lord, same adjournments, my lord. The court initially decided, the court is thereafter said that we are granting bail. You make your submission when it is convenient to you. So, my lord, there are instances, my lord, I don't wish to comment on that, my lord, but I just need a right to audience and nothing else, my lord, because 4 dates already they have taken adjournments. 20 adjournments before the lower court and 4 adjournments before the High Court. That is the plight of the, I do not know whether this man will survive or not, my lord. 2.5 years. I will show from the record what is his condition. I'll show from the record. I'll not make any submission out of record.
Lordship, my senior was appearing on last date, Lordship. LCR was called
You
for.
may take notes while
Okay, Lordship.
you take notes. I will hear your senior's reply
Okay,
after
Lordship.
hearing him.
I'm deeply obliged. My lord will kindly take note of few dates.
NCR is there.
Yes, my lord. My lord. This is a small today morning, my lord, after.
Now, since when the date of arrest?
Absolutely, my lord. 25/7/2021. So as on date, it is.
And what is the contraband?
Is Ganja,
How much?
360 kilo.
From where it was recovered?
It is from a vehicle.
You are the driver
No, I was found allegedly inside the vehicle.
along with the driver.
Along with the driver, allegedly I was found inside the vehicle along with the driver. I'll just demonstrate prima facie, my lord, whether any further custodial detention is required or not. Now, my lord, as on date, to be precise, it is 2 years, 5 months and 10 days.
And in days?
2 years, 5 months, 10
10
days.
days. And how many days? Only days.
Days. Days is 893 days.
893 days. Okay.
893 days.
Yes.
Now, my lord, as on date, only 3 witnesses has been examined out of 12 witnesses.
Okay.
Now, my lord, I had given a small chart, my lord. My lord will kindly look into that chart, my lord. These are the dates. Till date, 21 dates for evidence were fixed. My lord has seen that chart.
Yes.
Now, my lord will see they had taken as many as 18 adjournments. The last being yesterday. Yesterday also.
No. The prosecution has taken adjournment.
Witness has not come, therefore it was
Case is automatically adjourned.
automatically added.
But
My
it
lord,
is not a case where prosecution is seeking adjournment.
My lord, the witnesses are prosecution witnesses, my lord. If
They
the
fail to bring the
They
witness.
fail to bring the witness, my lord.
I am being produced every day from the jail hazard to the courts, my lord. I have no control over their witnesses, my lord. Now, my lord, charge in this instant case was framed on 10/6/2022.
Yes.
And thereafter, my lord, these 21 days were 21 days were fixed for evidence, out of which only in 3 dates evidence has turned up. And yes, my lord, I conceive that in one date, that is on 30/8/2022, the defense counsel took an adjournment, and I have fairly reflected that in that chart, my lord. Say even except this one date, in all other dates, your lordship will see, it is the prosecution which has taken adjournments. Adjournments in the sense their witness has not turned up, my lord. They failed to bring the witnesses.
Okay.
Now, my lord, my lord, here the contrabands were allegedly recovered on 25/7/2021. Now, my lord, will see in the LCR, there is an order dated 22/2/2022. It would be at the beginning of the LCR, my lord. 22/2/2022.
Yes.
My lord, will see after 7 months, they are making a prayer for drawal of the sample. And the prayer was allowed. My lord has seen that.
Yes.
Now, my lord, normally, my lord, within 48 hours, the samples are drawn, my lord, drawn in the presence of a magistrate. Now, here is a case, my lord, I am extremely confused because it is still at the trial stage, my lord. Initially, they have drawn, they are showing from the document that they have drawn it before the magistrate the very next day. But then, my lord, this order shows that they have made a prayer after 7 months. And the next page, your lordship will see that prayer was allowed.
Why this prayer was made?
Now, my lord, it is for the prosecution to answer.
No, what was their plea?
From the record, my lord, what emanates from that order is that their plea was to allow them to draw sample before the magistrate, 25 gram each. And accordingly, the prayer was allowed. This is how they are conducting the prosecution at the peril of a man who is in custody since more than 2.5 years, my lord. Now, my lord, I'll have to satisfy your lordship on section 37. Because, my lord, in NDPS case, there is section 37, which puts certain conditions for granting bail. Now, when the delay is about more than 1.5 years, then section 37 has no application, my lord. I'll satisfy, these are the judgments of Supreme Court and our High Court, where, my lord, if your lordship goes to the index, 1 year, 6 month delay, bail granted. These are all commercial quantity, my lord. 2.5 years, no criminal antecedent, section 37 would not come. And these are all recent judgment, my lord. There was a time, my lord, when section 37 was interpreted, was given a meaning in such a manner that it virtually makes the provision for bail redundant. Thereafter, because it was interpreted in such a manner that nobody, my lord, if we go by the strict interpretation of section 37, no person will get bail, man. But, my lord, of late, my lord, the Supreme Court has diluted that to the extent that once a man is there in custody for a considerable period of time, for more than 1.5 months or so, and the trial is yet to be concluded, in those cases, my lord, bails are granted. Not only the Supreme Court,
very recently in the month of December, a coordinate bench of this court, after going through all the judgment pertaining to speedy trial, right from কি আছিল এইটো সুনেরা খাতুন না কি আছিল হুসেনারা খাতুন since 1980, who said following all those judgments, my lord, 2.5 years bail was granted to two gentlemen, at least for two I appeared and many others, my lord, because that day all bail application pertaining to NCB was listed and it was fixed for hearing, because in all cases there were considerable delay for 2 years, 2.5 years, 3 years, 4 years. Even in one case I appeared where there was a delay of 5 years, and thereafter the person was acquitted. My lord will kindly come to page number 1, my lord.
No, before that, what is this Anjan Nath versus State of Assam?
Anjan Nath versus State of Assam here.
How much?
My lord, in this case, my lord, a bail was rejected relying on a case of Mohit Agarwal. Because Mohit Agarwal was on our High Court have rejected that bail. My lord will kindly come to that judgment, my lord. I'm glad that your lordship has pointed out that page number 5. My lord is there, my lord?
Yes.
My lord will see here, relying on the judgment of Mohit Agarwal, page number 9, para 15, and few other judgments, my lord, the bail was rejected at page 13, para 22.
Okay. What Supreme Court said?
Supreme Court said at page number 14, Anjana Nath, my lord is there.
Yes.
Supreme Court has said that since we are granting bail to similar persons who are in detention since more than 1.5 years or 2 years, therefore bail is granted.
For how long he was in?
Anjana Khatun, Datta,
Anjan Nath?
yes, he was arrested on 15/3/2022, page number 6, para number 2. Page number 6, para number 2, my lord is there.
Yes.
Now, my lord will see, this bail application was rejected on 19/7/2023, not even 1.5 years. And thereafter bail was granted on 17/10/2023. 22, March or 22. March 22, he was arrested and he was released on 23 October. March. 1 year, 7 months. Now, I take your lordship to the recent judgment of this court, my lord, of a coordinate bench of this court. My lord will kindly come to similarly placed case, my lord. Page number 51. My lord is there at page 51?
Yes.
My lord will see the order. It is December 1st, 2023. Mohit Agarwal was discussed. Satyendra Kumar Antil was discussed. Raghubir Singh was discussed, 1986, constitutional bench judgment on expeditious trial, qua Article 21. The court at para 21, page 56 has granted bail. Page 56, para 21 has granted bail. My lord is there at page 56, para 21. They were also in custody for 2.5 years. Similarly placed. And another coordinate bench, my lord, your lordship will see page number 60. That is another coordinate bench of this court. That is also NCB. They're all NCB cases. Then your lordship may kindly come to page 46. This is 1 year, 11 month.
Okay, your submission is that there are instances where, in spite of the fact that commercial quantity is involved, after lapse of 1.5 or more, the courts have given bail on the ground of prolonged incarceration.
Absolutely. My lord, in fact, in a recent judgment, your lordship would probably be aware that there was one judgment, my lord, Ravi Prakash. In Ravi Prakash judgment, in very clear terms, Supreme Court has said 3 years delay, section 37 will never come. Straight, no scope of any other interpretation. My lord may kindly come to that at page number 58.
Yes.
I take your lordship to para 4. As regard the twin condition contained in section 37 of the NDPS Act, learned counsel for the respondent state has been duly heard. Thus, the first condition stands complied with, that is giving opportunity to the PP. In this case, my lord, 4 months opportunity has been given. In my case, the one which I am arguing, because I have filed this bail application in the month of October. So far as the second condition, formation of an opinion as to whether there are reasonable ground to believe that the petitioner is not guilty, the same may not be formed at this stage when he has already spent more than 3.5 years in a custody.
The same may not be formed. What it means, the same may not be formed?
My lord, it means that the court need not form that opinion because he has already been in custody for 3.5 years. Because there is a second condition that the court will form an opinion that he is not guilty of. So that condition will not be applicable in a case where they have been in detention for a considerable period of time. Here, in this case, 3.5 years is written. That is on the fact of this particular case. But I have shown, my lord, the same apex court in more recent judgment has even considered 1 year and 6 month delay to be, my lord, is sufficient to waive the condition imposed by section 37, which has been followed by our court, my lord. 4 coordinate benches, my lord, have given bail in commercial quantities, notwithstanding formation of an opinion under section 37 in view of the fact that they have been in custody. And my lord will see whether this delay can by any stretch be attributable to the accused, my lord. And moreover, my lord, there is an absolute confusion regarding drawal of the samples because that order.
No, you are not on that.
I am not on that, but even, my lord, with these evidence, there is a blink chance of conviction, my lord. After 7 months, if a prayer is made, that samples should be drawn, my lord.
Okay, okay. When will you reply?
Lordship, next week.
No.
You have to give a specific date. We will, I will accommodate you, but you have to give a specific date. Because I have heard one part. Otherwise, I will forget.
Lordship, Tuesday, if possible.
Again, the same
Lordship,
adjournment prayer would come by.
Lordship, on last day, my senior appeared on last day, Lordship. We have filed our objection already.
Your objection is on record.
Yes, my lord, they filed their written, exemption is nothing but a carbon copy of what is there in their offense report. Written objection to this. This is the written objection which took
Okay,
7
I will go
months.
through. No, I want to hear, Mr. Though I have heard similar cases, the argument may be on similar lines, but it is a different case. So he has a right to being heard.
My lord, My lord, I am not saying, my lord, that it, because my lord, morning also, my lord, when the item was called time and again, my lord, I have. I
No,
have.
but there
compli-
is only one standing counsel of NCB.
Well, for that, my lord, whether people would suffer in jail. Today morning, my lord, when a prayer was made, my lord, I conceded to that, my lord. Again at 3
No,
o'clock.
this case has now been heard in part. I have already heard your case. I have
My
to
lord,
hear his reply and give
Lordship,
order.
yes, Lordship. Lordship, there are sufficient materials available on this, so my senior will reply. So many
Let,
materials.
let him reply. Heard Mr. M. Bishas, learned counsel for the petitioner. Though he has completed his part of the argument. However, Miss
M. Deka.
M. Deka, appearing for learned counsel for learned standing counsel for NCB, submits that the standing counsel for NCB would be replying in person against the submissions made by learned counsel for the petitioner on
Tuesday.
that is on Tuesday, that is 9/1/2023. Considering the nature of this case, the prayer is allowed. Let this case be fixed as part heard matter on 9/1/2023.
Well, subject to what your lordship says, my lord. Since my lord, her senior remains busy, my lord. Can it be at 2 o'clock, my lord, so that it is reflected in the cause list and there is a,
Yes, at 2 o'clock.
that may be reflected in the cause list, my lord, so
At
that
2
they
o'clock.
know. Because the other matter also, my lord, tomorrow another matter is due.
The time may be reflected in
In the
the cause list.
100%.
Much only.
Please. Can it be lordship on Monday, lordship?
Can be even after Bihu if you want.
No, otherwise, lordship is very simple, a small case, lordship.
No, let it be on Monday. I'm not insisting that it.
Lordship.
Heard Mr. F. Hawk, learned counsel for the petitioner, who prays for an adjournment due to personal difficulties.
Lordship.
Learned additional public prosecutor does not opposes the prayer, hence the prayer is allowed. Let this case be listed again on Monday,
Can be Monday or Tuesday?
Tuesday,
Lordship.
on 9th of
Lordship.
Did you call me?
No.
Tuesday.
I'm praying for some accommodation, my lord. Even the Monday or Tuesday, my lord. My senior left the court.
It is in order columns. Why it is in order?
LCR was called for, my lord. That is received, my lord.
So it will go for admission hearing.
Notice আছে নাকি notice?
Police হয়ে আপনার মধ্যে represent করিয়ে।
Whether notice has been served.
My lord, the
Respondent number 3.
informant is a police officer, my lord. So he is representing.
Okay.
He is representing.
What is the offense?
Offense is, my lord. There we have challenged the order of the session court, my lord. That is the office find at page 19.
Fake currency.
Fake currency was recovered from the possession, my lord. Initially, he was granted bail by the learned CGM, my lord. And thereafter, case was committed, my lord. And when application was filed for furnishing bail bond, my lord, the application was rejected, my lord. And charge sheet was filed after statutory period, my lord.
heard Mr.
Yeah, how are you?
A.
How are you?
Kawari. A. Hawari. A. Hawari, learned counsel for the petitioner, also heard Mr. K. Das, learned additional public prosecutor. The LCR which was called for has been received. Let this matter be listed for admission hearing.
On Tuesday, my lord, but he is in behind the bar, my lord.
Tuesday, everything may not be closed. After Bihu, after reopening, on 18th or 19th,
Even 10, 11, my lord. Because he is in.
10, 11,
My lord. Any date in the next week, my lord, any day.
let this case be listed again on in the next week. In the next week,
11 or 12, my lord.
no, date will be finalized by the registry.
Then it will not be listed, my lord. If the date will not be fixed, my lord, it will not be listed, my lord.
On 12th.
Obliging.
Made with the lordship. Lordship, in this case, respondent number 2 is appearing.
I'm for respondent number 2. For information.
What happened, your lord?
I have filed Okalatuma yesterday. Yesterday.
Lordship, this is a
It is
case.
in the orders column.
Lordship. Service is complete and the matter is very small in nature in the sense, your lordship. We have approached before your
We'll fix
lordship.
it for admission hearing or hearing. If service is completed, whether LCR would be required.
There is no LCR, I think, because only we are quashing of the FIR.
Quashing of the case diary would be required.
Custody.
Case diary may be required.
Custody already called for, I think, on the last order.
Whether case diary has arrived.
not.
Heard Mr. Heard Mr. A. Rahman
MH lost.
and MH Laskar, learned counsel for the petitioner, also heard Mr. K. Das, learned additional public prosecutor, as well as Mr. M. Hussain appearing for respondent number 2. It appears from record that the case diary of R.K. Nagar PS case number 81, 2023, which was called for, has not arrived. Hence, issue requisition for the same. Who will bring that?
As it is, and has not submitted, we can.
Learned additional public prosecutor shall ensure the production of the case diary on next date. List this matter for in admission column after 2 weeks.
The lordship will kindly fix a date, any date, your lordship, after reopening. 19th.
We are calling for case diary. A fixed date would be good.
Lordship.
Or on 19th.
19th.
19th. Oblige, lordship.
Okay.
For what? None appears for the petitioner on call. 33. None appears for the petitioner on call. From the office note dated 28/12/2023, it appears that neither AD card nor unserved notice in respect of respondent number 2 has been received back. Hence, await return of the service report in respect of respondent number 2. list this matter after 2 weeks.
Item 44.
34,
Made to.
34, 34.
In this matter, your lawyer, as per office order, as per the order dated 12/12/2023. We have already taken steps for service on respondent number 2. The victim.
Yes, your lordship, I'm appearing on behalf of respondent number 2.
Okay.
Victim.
Yes, for the informant. Your lordship, yesterday we have filed our wakalat and our names may kindly be reflected in the cost page.
You want to file affidavit?
No, we have not.
What is your prayer?
Lordship, this is a very, in this case, what happened, your lordship? Non-bailable warrant of arrest along with P&A was issued. In fact, I was never served with the summons, and from the record itself, it reveals that someone was neither served, neither bailable warrant was served, and without any record, your lordship, non-bailable warrant of arrest and P&A was issued, your lord. Page 26, if your lordship takes up page 26, the orders of the learned court below. What happened, the address that was furnished, your lordship, it is in that address, I am no more there. So they tried to make, I think, service on that address, and I was not aware, your lordship. Initially, I was granted bail. I was arrested in connection with the case, and I have been granted bail by the court, your lordship, during the investigation case. But after submission of the charge sheet, your lordship, no, I never received any summons, your lordship, and that is reflected in the order itself, your lordship. If your lordship takes up the orders, which starts from page number 26. And I'll more particularly refer to page number 28. The order dated 22/2/2022. If your lordship says accused is absent, summons to accused returned unserved with report that the accused could not be found in the given address. And subsequently, your lordship, initially bailable warrant of arrest was issued. Without getting any report regarding the same, non-bailable warrant was issued, and finally P&A was also issued against the petitioner. In another order, I'll take your lordship at page number 35. In fact, the process server was summoned by the court below. Page 35, lordship has got it.
Yes.
Accused so and so is absent. The process server Sri Junu Kumar Rao of Dispur PS is present. The process server submitted that the accused could not be found in the given address, and so proclamation was hanged in a conspicuous place. So, your lordship, in brief, I never received any summons, nor I was aware about the bailable warrant of arrest, your lordship. So I will appear before the learned court below. Same maybe. So there is a procedure prescribed under which if the accused did not appear even after receiving summons, then bailable warrant of arrest and then a non-bailable warrant of arrest can be issued.
Yes.
But this is a case where admittedly from the record, someone was not served upon me.
Let him appear.
My lord.
Let him appear.
No, sir, someone, it is not that, but someone was not issued. On a number of occasions, summons were
Summons were
issued,
issued,
but he was not available.
I'm not available in that address, your lordship. I was in a rented house. After that incident, I left this.
The
place,
case
your
is
lordship.
pending against him. He
No,
knows
but-
it.
No, but I was arrested. I was given bail also, your lordship. But subsequently, they did not provide the correct address for which.
You appear before the, you have any submission?
No, no.
Let him appear before the,
Yes.
heard, Mr. M.H. Laskar, learned counsel for the petitioner. Also heard Mr. D. Das, learned additional public prosecutor. As well as Mr. What is your name?
SK Chak.
S.K. Chakma,
Yes.
learned counsel appearing for respondent number 2. Learned counsel appearing for the victim. This application under section 482 of the Code of Criminal Procedure, read with section 401 of the said code and Article 227 of the Constitution of India has been filed by the petitioner Abhimanyu Das, impugning the order dated 17/10/2023, passed by learned special judge within bracket POCSO, Kamrup Metro, whereby the order for proclamation of the petitioner as an absconder and attachment of his property within bracket P&A was issued against the petitioner.
Even
And they,
before those days also earlier orders are also there. And earlier orders.
as well as when for the first time it was
First time it was issued, your lordship, on 22 to page 28. Not 28, your lordship. It starts at first. It was issued on page 32. 16 to 23, initially first non-bailable warrant of arrest was issued. Starts from,
but you have challenged which order? You have challenged 26(6).
yes, there is some. But when I have gone through the record, your lordship, it starts from 16th.
What is the last order?
Last order that it is 17/10/2023. Page 36.
No, what order was passed on 16/12?
But I have instruction.
Apart from you, there is other, you are the only sole accused in that case.
Yes.
First order is 69.
Hmm?
Page 49. Page 49.
Another order is there, subsequent.
Learned counsel for the petitioner has also submitted that,
It is the main order, P&A issued. So.
that along with the P&A, a standing non-bailable warrant of arrest was also issued against the present petitioner. It is submitted by learned counsel for the petitioner that the petitioner had never received the summons from the trial, summons issued by the trial court. It appears from record that though the trial court issued summons on several occasions, same returned without service due to unavailability of the present petitioner in the given address. Learned counsel for the petitioner has submitted that the petitioner used to reside in a rented accommodation and he had left that accommodation
After the incident.
after the alleged incident. And hence he was not aware of any summons being issued to him. It also appears from record that on 22/2/2022, the summons issued to the present petitioner were returned without service as the petitioner could not be found in the given address. However, the court issued bailable warrant of arrest of ₹3,000 against the present petitioner. And thereafter,
Page 32.
Continued to issue fresh bailable warrant of arrest on several occasions, as the said bailable warrant of arrest also could not be executed. On
Page 32.
On 16/3/2023, the trial court issued non-bailable warrant of arrest to the petitioner. Learned counsel for the petitioner has submitted that the trial court, without waiting for the report of the execution of bailable warrant of arrest issued against the present petitioner, had issued non-bailable warrant of arrest and thereafter ultimately issued P&A against the present petitioner. it is submitted by learned counsel for the petitioner that petitioner is ready to face trial before the learned trial court. And as the processes issued by the learned trial court were not in the notice of the present petitioner, it is prayed that some interim protection may be granted to the present petitioner so as to facilitate him for appearing before the learned trial court
And facing the trial.
and to face the trial. Considering the submissions made by learned counsel for the petitioner, learned that he would face the trial, learned additional public prosecutor as well as learned counsel for the respondent does not opposes the said prayer. Hence, this criminal petition is hereby disposed of with a direction to the petitioner, Abhimanyu Das, to appear before the trial court within a period of,
30 days. He's from West Bengal, Your Lordship.
okay, within a period of 1 month from the date of this order, and to facilitate his appearance before the trial court, the non-bailable warrant of arrest issued against him shall be kept in abeyance or
Maybe set aside, Your Lordship, because these were issued without following the procedure. He will appear and thereafter the court will decide. Just like summons, he will appear.
No, no, if he doesn't appear.
Now, if he does not appear, then the court will take its because.
Not cancellation, not kept in
In that
appearance.
case, Your Lordship, we will file our objection.
no, we are not setting aside.
Yes, yes, no, that is not the
It
procedure.
is, it will be kept in abeyance to facilitate your appearance. If you don't appear, it will revive.
Yes.
And my lord, he has to pray, perhaps subject to what your lordship says, because the bailable warrant of arrest was also issued against the bailer.
Yes.
He was also not cooperating to make his appearance sure.
No,
before
bailer's
the court.
case is different.
No, whatever I say, my lord, that is why my lord, he should take fresh bail. He should go on fresh bail.
No, on bail, I am not giving
In
any
the
relief.
discretion of the.
On bail, this court is making no observation. It
Right.
is that court will decide whether to grant bail or not. There,
That is what I meant to say, my lord. So he will file a fresh bail application, my lord, court will decide accordingly.
Once he appears, he may be put behind the bar. If the non-bailable warrant of arrest is not, because it is just.
no,
kept
it
in-
is kept in abeyance. It is kept in abeyance
Hmm.
and there,
And Lordship will
Okay.
clarify this as well.
on appearance before the learned trial court, the petitioner may seek appropriate relief before, may pray for regular bail before that court, if so advised. With this observation, this criminal petition is hereby disposed of.
Oblige, lordship.
Yep, yep.
I think item 26.
Meet please, Your Lordship. This is a 438 application number. FRS page 8, my lord. Sorry, my lord, at the moment the matter was called, I was in the other court, man. Page 8 is the FIR, my lord. And the main allegation is against Syed Ali, my lord, one Gaubura, my lord. That the Gaubura has, my lord, siphoned the money of the present informant, my lord. And the incident is of 2021, my lord. He has lost the FIR in 2022. Nearly 1.5 years, my lord, after the alleged incident, the FIR has been lost, my lord.
Maybe, what is the allegation against you?
My lord, my allegation is that, my lord, at the page 9, my lord, that one I am I am the accomplice of Gaubura, my lord.
What you did, what is the allegation?
My allegation is that, my lord, I have siphoned some money and with a promise to return her back, but I have not returned, my lord, along with others, my lord.
How much money?
She
56
has
lakhs.
alleged, my lord, my lord, a huge amount, my lord. It is around 56 lakhs, my lord. No.
What is your submission?
this, the allegation against the Kaubura, the Kaubura was arrested. Subsequently, he was released on bail, my lord. My role, my lord, I have not done anything, my lord. That is my submission, my lord. And my lord, and the incident is of 2022.
Yes, Mr. Duff.
And what amount, my lord, I have siphoned, he has not alleged. Yes, in generalized, he has alleged, my lord, that this much amount, my lord.
No, where is the allegation against you?
My page 9, my lord.
Read that.
In the affair itself.
In the page 9, my lord, after coming out from the bank, the accused and his accomplice Rahul Hawk, LIC agent Bob Borpeta and other
Which
accused.
line you are reading? Yes.
So from the top, my lord, 1, 2, 3, 4, 5, 6. That was the 7th line, my lord. From page 9, 7th line.
Okay. When the FIR was filed?
The affair was filed in the year 2022.
July
22.
You
my
are
lord.
not
22.
arrested.
No, my lord.
Now why are you apprehending arrest?
Now, my lord, police is after me, my lord. I am a name accused, my lord.
Yes.
Initially, it was registered in the Goalpara police station. Subsequently, it has been transferred to BIEO since it is an economic offense, my lord. Now, allegation against them is not this Gaubura, Said Ali was arrested. Some bank documents were also seized from him. His house was searched. And he says, my lord, Gaubura is my lord, not real Gaubura, not government appointed Gaubura. He is fake Gaubura. Fake Gaubura used to issue fake certificates of death. Suppose one person has died in the year 1990. In 2022, yes, after 2-3 years, he issues death certificate. And this from 1990, he opens one LIC policy in the name of that dead person, and subsequently, this LIC policy money is siphoned off.
So LIC people are also involved.
My lord. So basically, this is an economic offense, my lord. First, and his my lord, allegation against him is that my lord, he was associate of the, and as per statement of that Said Ali, the seal etc. were my lord, supplied to him by some 2 other persons. My lord.
No, against the present petitioner. What are the?
Present petitioner, he used to collect from the deceased family some documents, PAN cards, etc., and used to give them. Thereafter,
But when Gaubura has been released on bail.
my lord,
He has been released, my lord. Yes, my lord.
I do not have that information.
No, he was arrested.
In the case,
Subsequently
it is not. Yes, he was arrested. His
Well,
statements are also recorded.
Now whether, do you need his custodial detention?
My lord, that your lordship has to, I cannot say because
No, that is the main question.
yes, that is the question, my lord. But
Otherwise, I will direct him to appear before IO.
Not yet.
Because IO has not recorded his statement. He is
yes,
running.
that is correct. His statements is necessary because, my lord, my lord, as I understood, my lord, the case, my lord, some LIC personnel may also be involved in such. This is a scam, basically. This is a scam, my lord. So, my lord, I have objection, my lord. Your lordship may kindly record my objection also.
Heard Mr. S.M. Abdullah P. Where the Gaubura has granted bail, where is the document?
My lord, I don't have the order, my lord, but forwarding report can happen later.
I do not have that
But it
information.
may be recorded that
Bail order is
submission,
still there.
he was arrested.
S.M. Abdullah P. Learned counsel for the petition. Also heard Mr. D. Das, additional public prosecutor. This application under section 438 of the Code of Criminal Procedure. has been filed by the petitioner, namely Rahul Bhatt, who has been apprehending his arrest in connection with Walpara PS case number 153/2020 under section 120B slash 419/420. You have not mentioned BIO case.
But BIO, but we didn't know, my lord, after the CD game, we knew BIO case may also be, my lord, not in my lord, within brackets. BIO case number 14/22.
420/406/468.
This Gwalpara PS case has been merged in the BIO case, my lord.
4506 of the Indian Penal Code. It is submitted by an additional public prosecutor that the Gwalpara PS case number 153/22 has been merged with BIO PS case number
14/2022.
14/2022. The list of accusation in this case is that on 9/7/2022, one Manwara Khatun had lodged an FIR before the officer in charge of Gwalpara Sadar Police Station in inter area, alleging that the accused person named in the FIR, accused number 1 named in the FIR, namely Syed Ali, had introduced himself as village headman and secretary of the Kabristan committee and was issuing death certificate and birth certificate and other certificates to various people at different times. It is alleged by the informant in the FIR that after the death of her son, the accused Syed Ali came to his house and asked for the voter ID card, PAN card, and other documents of the petitioner's sons on an assurance that he would help the petitioner's informant son, that he would help the informant in getting financial assistance from the government. And subsequently, rupees 8 lakhs were withdrawn from the account of the informant on 25/1/2021, and thereafter on 28/9/2021, rupees 3,50,000 was withdrawn from the account of the informant. And it is alleged in the FIR that the accused number 1, namely Syed Ali, and his accomplice, that is the present petitioner, took the money from the informant with a promise to return the said money back to her. However, same has not been done, and it is alleged that the present petitioner and Syed Ali has siphoned of the money of the first informant. It is also alleged that the first informant was also given an assurance that an LIC policy in the name of deceased son would also be opened by the said Syed Ali. It is alleged that they used to open these fake LIC policy and used to embezzle the money out of these policies. When counsel for the petitioner has submitted that the petitioner is no way involved in the offense alleged in the FIR, it is also submitted that the main accused, namely Syed Ali, was arrested in connection with this case, and later on he was allowed to go on bail. It is further submitted that the petitioner is ready to cooperate in the investigation if he is allowed to go on bail. On the other hand, learned additional public prosecutor opposed the grant of bail to the present petitioner.
Strongly opposed.
Strongly opposed the grant of bail to the present petitioner on the ground that there are incriminating materials against the present petitioner in the case diary of BIEOPS case number 14/2022.
And he is one of the associates of this.
And he is one of the associates of the
Of
main
the
accused, namely
Syed Ali.
Syed Ali. I have considered the submissions made by learned counsel for the petitioner as well as learned additional public prosecutor, and has perused the materials available on record, including the case diary of BIEOPS case number 14/2022. It appears from record that though the offense was alleged, the alleged offense was committed in the year 2021. FIR was lodged only in the month of July 2022. It also appears that in the meanwhile, the investigating officer has recorded the statement of many witnesses except the present petitioner. Further, considering the ground that the main accused has already been granted bail, this court is of considered opinion that if the petitioner cooperates with the investigating officer, custodial detention of the present petitioner may not be necessary for fair completion of the investigation of the BIEOPS case number 14/2022. Stop. In view of above, the petitioner, namely Rahul Haq, is hereby directed to appear before the investigating officer of BIEOPS case number 14/2022 within a period of 10 days from the date of this order and cooperate in the investigation. If he does so within the stipulated period of time, in the event of his arrest, he shall be granted bail of rupees 30,000 with one surety of like amount, subject to following conditions. Condition number 1. Above observation.
Since it is a economic offense, some strict conditions may be there.
1, 2. What else?
My lord, he will not leave the
The petitioner shall not.
without
leave-
prior permission of the court.
The petitioner shall not. Where do you reside?
No, I said, Borpeta, madam.
What case is pending at? in
BIO Guwahati.
Guwahati.
So, madam, you will obtain permission from the, the IO.
He will not go out of the state, my lord, without prior
petitioner
permission
shall
of the
not-
lord.
The petitioner shall not leave the jurisdiction of the state of Assam without prior leave.
Of
Without
the
prior
investigating officer.
leave of the investigating officer.
Apply.
Obliged.
May it please, my lord. This application is for condemnation of delay of 27 days in filing this appeal, your lordship. So your lordship, actually what happened, your lordship, if your lordship kindly comes to the last page, page number 43, last annexure, there was a delay of more than 1.5 months in providing the certified copies of the documents, your lordship.
But whether you applied.
Yes, my lord. I applied on 11/8/2023. Last
within-
page 43. The first column on the top, your lordship. Date of application for the copy is 11/8/2023. And the second last column, date on which the copy was ready for delivery is 29/9/2023. So more than 1.5 months.
What was the date, period, limitation, when limitation?
Lordship 60 days, so there is a delay of 27 days.
When the judgment was delivered?
9th of August 2023, 9/8/2023.
Whether this period is minus or not, minus corona.
9/8/2023. And when the limitation gets over?
60 days, my lord, it will,
9/10.
yes, your lordship. Thereafter, there has been delay of 27 days.
But before 9/10, you were provided certified copy within the period of limitation.
My lordship,
Are you
No,
opposing?
that period has to be minus, my lord. From applying to receive, my lord.
Where have you mentioned the ground? In your petition?
That is the, my lord,
Paragraph 3, my
practice,
lord.
This is the appeal against
Conviction, your lordship.
conviction. Yes, what is your submission?
No, yes, that period is, that is the, my lord, normal practice, my lord, that period has to be.
Considering the ground, it may be condemned. Mr.
It's there, my lord.
S. Day, learned counsel for the petitioner. This interlocutory application has been filed under Section 5 of the Limitation Act 1963, praying for condonation of delay of 27 days in preferring the connected appeal, in preferring the appeal against the judgment dated 9/8/2023, passed by learned Additional Session Judge Sipsagar in Sessions Case number 81 within bracket SS/21, whereby the present petitioner was convicted under what provision?
306, your lordship.
Convicted under section 306 of the Indian Penal Code and was sentenced to undergo rigorous imprisonment for life, rigorous imprisonment for 5 years, and also to pay a fine of rupees 5,000. And in default of payment with default stipulation. So, learned counsel for the petitioner has submitted that the delay in preferring the appeal, delay of 27 days in preferring the appeal was due to delayed furnishing of certified copy of the impugned judgment to the present petitioner, though the petitioner had applied for the said certified copy within time. Stop. Learned, considering the grounds mentioned in where are your grounds in
Paragraph 3, my lord.
in paragraph 3 of the condonation of delay application? The learned additional public prosecutor also does not opposes the prayer for condoning the delay. Stop. Considering the submissions made by learned counsel for the petitioner, as well as grounds mentioned in paragraph 3 of the condonation of delay petition, this court is of considered opinion that delay in preferring the appeal has been sufficiently explained by the petitioner. Hence, the said delay of 27 days in preferring the appeal against the impugned judgment is hereby condoned. Let condone this. Let the appeal be registered and listed
In admission, my lord, it will come from.
after registration.
There's also an interlocutory application, both be registered, your lordship.
It will be
Appeal and-
automatically once, and this interlocutory application is accordingly disposed of.
Much obliged, your lordship.
Leftover dates will be given by the
May I just make a
Court,
request?
courtmaster, yes.
Come from out of station, my lord, and this matter has been listed in the category of final hearing, item 39, my lord. It pertains to a complaint of primarily forgery, my lord, which was lodged way back in 2019. And there's a stay operating against one of the cognizance taken by the learned magistrate in July 2022, my lord.
Which item?
39, my lord, item 39.
Now, what
I'm-
is your prayer?
My lord, I'm only requesting if it can be kept on a specific date, my lord. I've
Okay.
consulted my learned friend also, and
Okay.
he's agreeable to 22nd of
No, he will give dates according to our. court
subject to convenience, my lord.
You take date as per your convenience, subject to. the-
Convenience of the court.
Yes.
No, and may I request if it can be kept in the category of admission, my lord, because I have also moved an application for vacation of the stay.
But it has already.
No, it has already been admitted for
Admitted.
hearing though.
Yes.
has
Now
been,
again,
but
it cannot be.
it
I
cannot
don't
go
think
back.
so, Lord.
But it's always in the
That's the
end of the
procedure.
list, my lord.
That's the
procedure.
problem in the bail court. When bail matters are there,
My lord.
we have to give preference to.
I bow down, my lord. If it can be only kept in the category of admission,
No.
considering that
cannot
I
be-
moved an application also.
On the date fix, you may make a mention.
My
On the
lord.
date when it is listed,
My
you
lord.
may make a mention for either upgrading it or such kind of mention. You may.
Obliged.
Obliged, sorry.